Yes.
Not one application in connection with first appeal. One application in connection with first appeal of 2011.
2011.
And one hearing of 2002. Old appeal.
Hearing just
Once it is dismissed for default, I am for the
whatever. Wait for that. Wait for that. Give application.
May I be permitted to mention item number 133. Your lordship was heard this matter. Matter related to the appellant for your lordship.
My brother did not hear. You said heard.
Your lordship's heard that is we are not in
Plural form, singular form.
Kindly, what happened, we are not getting our salary. After you got this,
Let the regular bench comes. We'll take up this matter.
we are not getting salary.
We'll take up. This bench is only for this day. Kindly consider. There will be another judge from tomorrow. Wait.
May I come back?
Please come back tomorrow.
The courtroom, this matter relates to courtroom 12. Since the bench is not sitting, the determination has been given to you.
What is an urgency?
The urgency, it relates to mandamus appeal group 1. For 14 days, the courtroom room number 12 will not be sitting.
Yes.
And the
So
blanket order has been passed.
what?
It was directed to be heard on 12th. It was filed and it was supposed to appear on 12th. But I have been told that since the bench is not functioning,
Whatever, there will be a partner of that bench from tomorrow with me. Come tomorrow.
then I
Order is passed on.
24th January.
Have you annexed the server copy? Applied for certified copy? Have you annexed?
May I permit mentioning for determination of justice in court Tapabrata
Why
Chakraborty?
don't you come tomorrow?
May I have your lordship's leave to mention one matter for admission of appeal arising out of Employees Compensation Act?
Employees Compensation Act. Give
Grateful lordship.
the order 41 for admission. Yes.
Kindly to mention one application for information.
Application in relation to group 2.
For the respondent, my lord, last occasion, my lord, appellate want to their intention to withdraw the appeal.
Yes.
I am leaded by Mr. Sen.
অর্ডারটা দাও সই করার জন্য
করে দিয়েছেন
করে দিয়েছো Where is the appellant?
yesterday. The lady was there.
Preemption money.
What?
Final DP proceedings money. That's why they're changing. Advocate now should not appear.
Where they appeared yesterday. Now when we are taking up the matter, nobody is appearing. Then we are dismissing it for default.
But it will be not today for the
What not today?
that's our talks. Dismiss for default after restoration.
And making a Passover, call him.
Number 2.
But I am for the petition in this one. And this is the affidavit of service I have served to all.
What is this?
On a petition of referred to your lordships, the purchase of a land in the year of
Just 1
Give us a
minute.
second.
Just 1 minute.
Mal. এক নম্বর পাস ওভার আছে
refusal to stay the order
Yes,
passed
sir.
in an appeal.
Yes, my lord. Well, your lordship will find.
Are you sure?
Yes, my lord. I
My
will.
own judgment is against you. Whether my brother will concur or not, that's a different.
Yes.
My own judgment is against you.
Your lordship will find Honorable High Court in the division bench passed an order directing the tribunal, my lord, page 44. They have filed a public interest litigation. In the said application, no order was passed direct to file appeal. You can.
To challenge the order before the prescribed authority under
Yes.
the West Bengal Land Reforms Act by filing an appeal before the appellate authority. If such
Yes.
appeal is filed, the appellate will issue a notice and decide the maintainability and locus.
Yes, my lord. I have filed an application for maintainability and locus. But they have no locus, no share is
Whatever
there. After 12 years, they have.
the appeal court before the appellate authority, they filed appeal.
Yes,
You went there.
I went there, I
and
filed
you
an appeal.
say the maintainability.
Yes, my lord. In view of this order, my lord, I have
Correct.
filed this application.
The appellate authority will decide.
Yes, my lord. Appellate process will decide, but without rejecting or taking steps for maintainability, they have directed to file an affidavit in the whole matter.
So definitely.
Therefore, my lord,
because they wanted, this is a tribunal, sir. And
thereafter I went to the trial. When this matter was not taken.
correct. Where is the order of the appellate authority?
But appellate authority order is the last order which your lordship.
No, this is the order of the tribunal.
Tribunal.
Where is the order of the appellate authority?
Before that. My lord, I.
64.
Yes.
64.
Before that, 70.
64, page 64, my lord. On their request, time has been granted. And they have given the opportunity to.
Just 1 minute.
No,
Sir, you did not have.
sorry.
It is their appeal
One.
application. Let them. No, which order was challenged before the
My lord, that
tribunal?
10th of December 2024, page 64.
10th of
10th
January.
December?
2024.
My lord,
This
20
is what I really wanted.
10th of December 2024, page 64 of the.
Just 1 minute.
My lord, 28 January
Yes,
2025. Thereafter.
So before the appellate authority, appeal has not been disposed of.
No, my lord. No, my lord. The application has been filed for maintainability as the direction was passed by this honorable division bench of this honorable High Court. I
So
filed.
where is a stay of the operation of the order? You have asked for a stay of the operation of this order,
Yes, my
which
lord,
is
I
refused by the tribunal.
refused by the tribunal has only passed.
What stay of this order can be passed? Tell me.
My lord,
If
I,
this is an order of 10th December 2024, which is assailed by you before the tribunal,
Yeah.
what stay order you expect from the tribunal against this order?
but I filed an application challenging that the
Sir,
maintainability.
that is maintainable. Please kindly consider. An appellate authority has been approached in terms of the liberty granted by this court. This court observed that the point of maintainability or the locus standi can be raised by you before the appellate authority. They filed an appeal in terms of that liberty granted by the High Court. You filed an affidavit raising a point of maintainability and locus.
Yes.
The tribunal, after considering this, has given an opportunity to the parties to come with all the documents, and the date for hearing of the matter was fixed.
Yes.
Challenging this order, you approach the tribunal.
On the tribunal.
Maintainability,
Yes, appeal.
maintainability of
Yes.
the tribunal application should be taken up first.
Yes.
The government has raised this issue. Maintainability point is still to be decided by the appellate authority.
Yes, my lord. For that reason,
So
my lord,
they
I
will
want to,
decide it. They have fixed the matter on 28th.
not
They have to
next
decide
date,
it.
my lord, tomorrow is fixed. And
Tomorrow
20
means 28th January gone.
yes, my lord, 20th is fixed for hearing of the tribunal.
No,
before
appellate
the
authority.
appellate,
Correct.
appellate authority, tomorrow is date fixed for hearing. And directed,
So you did not participate before him on 28th of January.
my lord, I,
Did you participate
yes,
before
my
the
lord, I
appellate authority?
participate through my
He took-
junior. Yes, my lord.
Did you argue
I-
your matter?
No, my lord, I,
Why?
my lord, I prayed for time as,
Why you prayed for time? Because you have moved the tribunal.
yes, the tribunal has directed to file affidavit
My lord, on his
and the
No.
matter is fixed.
Sir, why you have invited the tribunal to do that?
Yes, my lord, I invited tribunal as the,
Sorry,
Oh,
we don't
oh.
find at the matter.
my-
He's jumping the forum. He's
No, as
jumping
the court-
forum. The original forum is yet to decide the point. He wanted to be
we-
decided by the High Court. Everything will be decided by High Court.
my lord, why? My lord, there is a,
Sir, he will be losing. Suppose if it has gone against him, he will be losing a forum.
my lord, no, my lord,
If
no, he will
decided-
not be losing, my lord.
You wanted us to decide the maintainability point,
Yes, my lord, they,
correct? If we decide the maintainability point, do they have a right of appeal? No. They have
Yes.
to go to the apex court only one forum, and that.
no,
is
your
not a
lordship, I
regular
do not
forum.
want to, my lord, I do not want to. Yes, I only want to not to pass the appeal court for time being, let the matter be decided by the tribunal.
Why
Tribunal,
tribunal?
my lord, this is the land reforms tribunal, that is the
Sir,
pending.
the tribunal is really acting as an appellate authority
Ye-
over the
Yes,
statutory appellate authority.
yes, my lord, yes, my lord,
So
yes, my lord.
if the tribunal decides, then
Regarding the
then-
maintainability, that
Correct.
they will come before this court.
Correct. So they lose one forum of tribunal.
They
If
will
the
come.
appellate
Privilege,
authority decides,
My lord,
they can challenge that order before the tribunal.
what is the
That
difficulty?
forum is available.
What is the difficulty of me?
The difficulty of being is,
My lord, what is the
you are
difficulty?
creating a difficulty, Mr.
My lord,
Arun.
I'm mentioning.
At
2012, my lord, mutation has been passed. After 12 years, my lord,
I would have kept mum.
but
and,
after
decide.
12 years, they have filed an appeal. For that reason, court has directed to take maintainability. He has no share of this property. He has no locus standi of this. Why I shall disclose my defense? This is the problem. Why I shall disclose my defense on that?
My brother is to be convinced.
Never, Lord, I will,
Convince him.
but I shall try to convince.
Convince him.
Well, appeal court directed me to disclose your defense. And High Court has directed, first of all, we take the maintainability and locus. But therefore, my lord, I file an application.
Sir, maintainability point can be decided at the time of the disposal of the appeal also.
That can be.
Where is
No,
the
no,
difficulty?
when the High Court has directed, well, that can be. When the division bench has directed,
Maintainability
you take
point
this.
Maintainability point is still open or not? Before
Maintainability-
the appellate authority?
Yes, that is open.
Then why you approach the
But I have,
tribunal?
why I have filed, why I have prejudice for disclose my defense. Well, your lordship kindly know, appeal court has directed me to file affidavit in opposition in the main matter. Therefore, my lord, I request the appellate authority to decide that. They have no locus standi. They have no locus standi. High Court also see that. There is no locus standi. Public litigation interest, public interest litigation, they have filed. That was not taken into care. What is the cause? I am taking construction about the water body. How the water body has, they have filed an FIR against me also. That was also dismissed.
Sir,
No such thing.
while passing the order dated 10/12/2024, whether the statutory appellate authority has passed any order that you will not hear the point of maintainability at the time of hearing of the appeal?
No, I have filed
Yeah.
I have
Why you
filed,
approach the tribunal and ask for stay?
I have filed an application. As your lordship kindly see.
Convince कुछ
I am not convinced.
I want to try.
No, sir.
he
I want
realized
to
that,
try. I have,
nothing would happen
I-
before me. So he tried,
Nothing. No.
I want to
tried
try.
to,
But that maintainability point, if they have not decided, the appeal court, Well, what would be my difficulty? Why I shall disclose my defense.
একদম
It
ট্রাইব্যুনালে
is,
চলে
it is
যেতে
a classical example of
No, my lord, I have not taken that. That cost point is,
Why not?
they cannot.
They cannot, then they have to suffer. That will be realized as a land,
No, my lord. That one I have not say anything furthermore.
land revenue.
I cannot
Will be giving the
Item number 3, my lord, Lane Advocate General is applying for the state.
At top.
My lord,
I think it is at the top.
my lord,
That
my,
you ask for an accommodation.
my lord.
We asked you whether you will be able to do the case. You said that it's a matter on 11th. Advocate General will come.
My lord, my lord, with folded hands, my lord, one humble request.
We are denying.
No, my lord, one humble request. My lord, kindly, my lord.
Don't
My lord,
embarrass the bench. The date was fixed at your request. We
My lord.
asked you to, you kindly inquire from the Advocate General when he's, for which date is convenient. You said on 11.
my lord,
Now it's a high time. One should know. Bench cannot be.
no, not
like this.
not that, my lord. My lord, the thing is this, my lord, the Advocate General is otherwise busy, my lord. On 18th, my lord,
Very busy. There is no doubt about it. Nobody can deny. He has a greater responsibility. When on 16th January you asked for 1 month time. We readily extended that time. From 16th
I am
January,
proud
the
of-
date was fixed on 11th of February. Because you wanted the Advocate General to come.
my lord, I bow down to your lordship, my lord. My
Now
lord,
when the matter is taken up, Advocate General is otherwise busy in
no,
another.
my lord, may I
That
submit?
means he is least interested in this.
No, my lord, not that. My lord, may I humbly submit one thing?
Here,
My lord, may I submit one thing, my lord? My lord, one thing, my lord. Kindly allow me for a moment, my lord.
on his prayer, that was on 16/1.
My lord, may I submit one thing, my lord? Just.
11/2, nearly 1 month. We
Um,
granted him time.
my lord, may I submit one thing, my lord? My lord, kindly fix 18 at 10:30.
We don't lie.
No, my lord, on 18th.
Past incident,
My lord, what
the
happened?
incident in presentee does not give any confidence that on 18 you will be able
No, my lord, the
show
Advocate General personally, I have talked with him, my lord. He has assured me that
That day also he assured you that he will come on 11.
any day, he said, my lord, any day.
Because on that day, everybody appeared.
My lord,
No, sir.
if it suits your lordship, kindly record that it's a last chance, my lord.
Embarrassing to me.
My lord, kindly record that it's a last chance on 18, my lord.
That's embarrassing.
No, my lord, kindly record that and your lordship.
Embarrassed.
My lord, I'm extremely sorry for that, my lord, but the
Not have that sense. But really, it's an embarrassing moment
my lord,
that the court is taken for a ride.
no, my lord, no, my lord, my lord, my lord,
Example.
well, on 18th, the Advocate General has expressed his view that he will be on 18th on 10:30 and 10:30 sharp, my lord.
He expressed his view on 11th also.
No, 11th, my lord, what happened, my lord? He said that any day in February, first week, first week, Mr. Jana was otherwise busy, my lord. Second week, my lord, on 18th, my lord,
What more?
with folded hands, my lord, on 18th, my lord.
I'm reciprocating that.
My lord, kindly do not do that, my lord. I am a little
No.
my junior member of the bar, my lord. I will be very much embarrassed for that, my lord.
You are there live. What the country will think about you. You are live.
No, my lord.
What the common litigant will think. That
But, my lord, it's a
1 month before,
My
on
lord.
the ground of the London Advocate General, the bench said that whatever the date which suited London Advocate General, we are ready to fix. We fix the matter today. Again,
May I prefer, may I prefer one thing, my lord? My lord, on 18th as a last chance, my lord, kindly record that, my lord, 18th is a last chance. My lord, 18th is a last chance, my lord, kindly record that, my lord. Otherwise, my lord, I will not stand in the way, my lord. They will proceed, my lord.
let them proceed.
No, on 18th, my lord, if Advocate General does not come, my lord, let them proceed, my lord, on 18th, my lord.
The main, the sufferer is the
On 18th, my lord, 7 days only, my lord. We are on,
respondent is the main sufferer.
today we are on 11th, my lord.
They are not sufferer,
Yes.
nor the state sufferer. The private respondent is sufferer.
No, Lord,
Who receive, who
Or private
who must successful in the single bench. They have come. They have the authority.
We are on 11th, on 18th, my lord, 7 days only, my lord. Well, kindly record that it will be last chance, otherwise, my lord, they will proceed, my lord.
These are the practices which is prevalent in the trial courts. Special chance, last chance. My brother will share that experience. Last but last chance.
Your Lordship has
High Court
enormous views on that, my lord.
some tradition. Has some
My lord,
tradition.
my lord, I have talked, my lord.
Not come across. I don't have.
No, your Lordship,
On that side, I had lot of experience in other courts as well.
yes, your Lordship was in civil court for a
Other
long period, my lord.
I never saw these kind of a things. When a date is fixed, everybody comes ready on that.
My lord. But my
Other
lord,
high courts I never found.
my lord,
This high court I am getting.
no, my lord, my predicament is this, but the Advocate General has requested me to pray for one day, only on 18th, he will be there, must be there. Wow.
What is a request to you? But that does not mean the court will accept the prayer.
That's true, my lord, but on behalf of the Advocate General, my lord,
Convey to the London Advocate General that the court has rejected the prayer. I have complied your request. The court has not accepted.
my lord, on behalf of the Advocate General, my lord, I am requesting the bench to my lord, fix my lord, on 18th. My lord, on that day, if the Advocate General is not there, my lord, they can proceed. My lord.
No,
My lord, I will not stand in the way, my lord.
matter is pending on this ground.
Yes, my lord.
I'm just giving, it must be known to each and every person who is watching this. I am the first order which was passed. You are the respondent number 2.
My lord.
On 19/8/2024, on the joint prayer of the appellant and respondent number 2, the matter was directed to be listed after a week. The appellant did not appear on the returnable date, that is on 17th September 2024. Only the writ petitioner respondent appeared and state appeared without the learned advocate general. The matter was fixed after the puja vacation. Then on 19th November, Mr. Rajaram Banerjee
My lord.
appears
For the
and
state.
submits that learned advocate general sir appear for the pro forma respondent in the instant.
My lord.
He is unable to participate in the proceeding today and prays for an accommodation. On consent of all parties, the matter was fixed on 27th November. Then when the matter was taken up on 5th December again, then on the prayer of both, it was adjourned. Then on 10th of January, accommodation is sought on behalf of the state that learned advocate general will appear and address the court as he is appointed in the instant matter, as it would impact the entitlement of the retired school teachers and non-teaching staff on awarding the interest on pension awarded during the interactive period from the date of superannuation as the date of the and the date of the refund in terms of the special bench judgment. Then the matter is fixed on 16/11. 16/1. 16/1 when the matter is taken up. Accommodation is sought as the learned advocate general is engaged in another court. On consent of parties, the matter is fixed today. What it conveys.
My lord, though it's not relevant, my lord, during
Relevant.
no, my submission will be irrelevant, my lord.
Oh, it is not relevant. What are you talking?
For my submission, my lord, what I am going to make, my lord. In the meantime, my lord, your lordship knows that the learned advocate general was admitted in the hospital. During that period, also I prayed for time.
When he was admitted, prior to 16/1 or after?
No, prior,
16/1?
no, prior to, very much prior to.
So if it was prior to 16/1, then this was the situation. We took into account that he needs a time to recover.
No,
1 month.
in the meantime, he has
1 month
recovered, my lord.
time was given to you, sir.
Yes, my lord.
And it was on consent this matter was fixed today.
Yes, yes. Lord, I bow down to your lordship, but kindly, my lord, fix 8.
But lordship, here our problem in lordship, I lordship, but here lordship, only lordship, only my prayer lordship, only one thing lordship. Lordship, my prayer, Lordship, only Lordship, the Advocate General is Lordship.
Why? You are the appellate.
No, Lordship, I am the
sir.
appellant. No, state and,
General will
but if the
take
Lordship,
care of that.
Advocate General argue the matter in the read
No,
court,
he
Lordship.
will argue for you.
Lordship, but
He
Lordship,
will argue for you.
but when the
Appellate,
appellant, but
private respondent is saying.
We have no other difficulty on behalf of the appellant.
You
Only thing is this.
no thing is this.
no, Lordship, only, Lordship.
If
Only thing is continue and argue.
Only give me, Lordship, in the
Only thing.
in the our side, Lordship, I am praying for only 1 week.
No, sir.
Allah,
In
yes,
the our side, Lordship,
Allah,
Lordship,
No.
I could not, Lordship,
yes,
to Lordship,
Allah,
Advocate General.
yesterday I have heard from your lordships that, my lord, that if it is a big matter, the matter may not be finished today. Now, my lord, the other matter adjourned, my lord.
No, we kept this matter so that whole day we will
Yes.
invest and continue and dispose of them.
That Lordship, I am praying only for Lordship, give me a chance.
Don't worry.
I,
Matter was fixed.
my,
Lordship,
that is
that's
true.
our Lordship.
That is true.
In the first hours we have taken.
Lordship, give me, Lordship.
I don't think so that you will argue
No,
7
no, no,
hours.
no, no.
or 8
Yes, I don't think
On
also
this
that
point.
that this matter.
hours. Very small.
Yes, yes, that is true.
Give
That is
me
true.
one chance. Lordship.
Only the certain facts and only some relevant points, law point.
And law points is the only
Yes,
point.
yes.
That the interest can be avoided. That's all.
Yes,
The only thing.
res judicata and other
Whatever,
point. Yes,
judicata,
yes.
you show us the earlier
Yes.
judgment and everything.
Yes.
There is no difficulty. We'll consider. We know how to apply res judicata.
That's true. That's true. My lord's own judgment, there are so many judgments.
Lordship, give me a chance.
On a principle of section 11, we'll
Yes.
consider it.
So otherwise, Lordship,
নিশ্চয়ই সিপিসিতে এনেছো
give me a chance.
I am giving you. Don't
No,
worry.
no, no, no.
I have got a
No, 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 Lordship have.
full
Lordship.
copy here.
No, no, Lordship, I know, Lordship.
Here,
No, no, no,
Very
Lordship,
good.
not in. And দরকার নেই, দরকার নেই।
here.
আরে দরকার নেই।
Which explanation? Explanation 1, 2, 3, 4, 5, 6. Which explanation
Fine,
you want? Tell us.
Lordship, only Lordship, give me opportunity, Lordship, only 1 week, Lordship. Only 1 week, Lordship. I am on
Very good,
behalf
Malab.
of.
Madam, may I tell Lordship? Otherwise, Malab,
Otherwise,
ready. Lordship,
Otherwise
Lordship, kindly
ready, then
kindly give the last chance because
Lordship,
we also, Malab, want his assistance on the next day. So, Lordship, kindly.
Otherwise, Lordship,
instead
we
of-
argue the matter.
We
Lordship.
also want his assistance. I think, my lord, the advocate general's assistance. I can argue, but his assistance is also required. So, lordship, kindly give a last chance. Since my learned friend also, my lord, on behalf of AG said that, my lordship, I think, my lord, I think that
No, no, no.
this
definitely
matter,
not.
his presence is necessary.
Oh.
So, lordship, kindly 1 week time be given, lordship, kindly.
Give me a chance.
His presence is necessary.
Only 1 week.
And, what is the point? You argue, then if they are not interested, you
No,
argue.
no.
We have looked at short lists of nets. So that will also.
Then Lordship, I argue the matter. Then I argue.
May I?
But
May I start?
Where start the
If you lordship.
please argue.
But may I, before going, may I? Malad, in 2013, very short, Malad, before Malad,
Take microphone, sir.
my lord.
Take microphone.
Oh, yes. Now, Malad, before Malad going to the opening the brief, may I just tell the facts, Malad, in a nutshell, my lord. Now, my lord knows that in 2013, a special bench was constituted for the purpose that whether, my lord, the teaching and non-teaching staffs of primary schools, who, my lord, submitted their prayer according to that rupa, that with
2009
to
or
ROPA 2009 with
1990.
1990. 1990. That my lord, that if they agree to that pay scale, then my lord, whether they are entitled to pension and pensionable gratuity or not. Then my lord, that special bench judgment in 2013 held that in view of that ROPA, my lord, they are entitled to pension. Now, my lord, but the order was, or the judgment delivered, that the pension payable upon refund of the employer's provident fund and from the date of provident fund.
I mean the
Employer's contribution, whatever already,
provident fund.
yes, whatever already paid, who had retired,
To return.
they have to return the employer's share of provident fund with interest. But at the same time, when pension would be payable from the date of refund, it is stated therein, but the employees, they are not, my lord, there is no obligation on their part, my lord, sorry, they are not entitled to any interest.
It has been held by the
It has
special
been
bench
held.
that they are
It
not
has been,
entitled to any
yes,
interest.
only, yes, that is the settle, that only the area pension, and that also to be, my lord, accrual from the date of refund, not from the date of their respective superannuation date. Suppose, my lord, superannuation date
No, I
2000
say
to
some
2001.
superannuation is in 2000, the refund is made in
2014. 2014.
2005. Let us see.
Yes.
So it will not reckon from 2000, but 2005.
Yes.
That's the date of it.
Yes, that was the judgment. Then, after that judgment, a notification was issued in terms of judgment in 2014, inviting that and intimating and inviting application for pension, and that was going on. Implementation of that particular judgment of special bench, there was no problem. But after that, time to time, certain individual writ petitions filed by some of the teaching and non-teaching staffs, they claim that they are entitled to, my lord, the pension from the date of that respective superannuation. Now, eventually, again, the matter referred to the special bench. Another special bench formed in 2019.
Same strength.
Yes, 3 judges bench.
Both.
Yes, yes. 3 judges bench. Now the special bench held that no, the expression of pension in terms of the several judgments, it's a trite law that the pension is payable or the employee is entitled so far the pension is concerned from the date of their respective superannuation. So the state has to pay the arrear pension from the date of their respective date of superannuation till the date of that refund of that their individual, I think the overpayment, I mean that provident fund. That means the balance period, which earlier was not paid, now the state has to pay. Now here also in that special bench judgment, there is no whisper about my lord, the payment of interest. That is silent, so there is no question of payment of interest, 7 except that arrear quantum from the date of superannuation till the date of refund of we accepted that. Accepted, I mean, after Supreme Court.
And you paid.
Paid, my lord, may I tell? My lord, after that, this payment cannot be made on a particular day or my lord, all on a sudden, but the my lord knows the system of this payment is always that my lord, the person concerned, he has to, my lord, fill up certain form, prescribed form has to apply, then only the process started and the pension is being paid. There are thousands of, my lord, the persons entitled to. So the process started on the basis of the application and the filling up of the prescribed format, and the process started. One after another process started. Now, in the meantime, a group of petitioners, those
Sir,
who are
sorry, process started for disbursing
this area
pension from the date of superannuation to the date of refund.
to the date of refund,
But dictum of the
special bench,
judgment of
second
the
special
second
bench
special
judgment
bench.
in 2019 delivered.
Very good.
Now, my lord, the group of, my lord, the entitlement who were entitled to, my lord, they filed one after another writ petitions. Now they claim interest in respect of that arrear pension, which is otherwise payable in terms of the second special bench judgment. And that group of writ petitions clubbed together, heard and disposed of, and which the judgment is, my lord, is under challenge in this writ petition. Now, there the question, let's say kindly, my lord, there the question arose. There the question arose is that most of, barring a few or almost all, those writ petitioners, they had filed their independent writ petitions prior to that particular writ petitions, which are subject matter of that, my lord, particular, my lord, the judgment under delivery, my lord. Now, there, my lord, there was a specific prayer in their writ petition for interest. And when those writ petitions were disposed of by the learned single judge, when that special bench judgment was pending, I mean special bench matter was pending, second special bench, there the interest, my lord, the learned single judge declined to grant interest. Learned single judge said that no, pay the arrear. So when this independent, another writ petition, all those writ petitions, here again interest, and only interest. So this point has been raised before the learned single judge. That when these particular petitioners, their independent writ petition, despite being the fact, was allowed only to the interest of arrear pension, but not, though they claimed therein, but the court did not allow or did not pass, then whether that is, my lord, barred under, my lord, section 11, my lord, that is explanation 5. Now the learned judge said, and apart from that, when special bench said, did not express anything with regard to interest, a 3 judges bench, then whether a learned single judge can pass an order, practically, my lord, modifying the judgment of the single judge, or my lord.
I could not get this point. If the point of reference, it is not the special bench who decides the main matter.
No.
Special bench supposed to answer the reference.
Yes.
If the reference does not include the grant of an interest, and the reference was only relatable to whether the pension, they are entitled to receive pension from the date of superannuation or from the date of the refund. And if the special bench has answered that it is from the date of superannuation, can you say that they are stopped from claiming an interest, because that was not a point of reference?
My lord, that particular, my lord, the reference.
There is a distinction.
Yes.
If the writ petition or any other appeals are being referred, it is only the reference, point of reference, which is to be decided by the special bench. Only exception is the revisional application under section 115 or 227, where the special bench has to decide the matter on merit as well. This is the only fine distinction in terms of our appellate side rules. So the matter after the reference is decided, reference is answered, the writ petitions are to be reverted to the respective courts to decide on merit on the basis of the law so enunciated by the special bench.
My lord, that is true. What, my lord, what failed from your lordship, that is true, that the question referred to, or the points raised before the special bench, that is the answer. Yes.
It's not a question of decision of the list.
Now,
it's a question of answering the reference. If they claim,
my lord,
that no, I am entitled to from a further date, then you can definitely say that once that is decided, you cannot reopen after the special bench. But so far as the question of interest is concerned, it was not a point of reference.
Well, I shall come to that, my lord.
That
That,
is
yes,
what
yes,
the
my lord,
question
my
from
lord,
the
yes,
I derived.
my lord.
That's an
My
inspiration.
my
I
lord,
derived.
I shall try to convince before your lordship that
Second point. First point,
yes.
res judicata, I can understand.
yes,
I
yes.
have not said anything on that.
So, my lord,
Second point, I was.
so my lord,
having-
these are the points before your lordship with regard to this
Let us
appeal.
now go through the impute
Now,
order.
my lord, may I tell? Now, my lord, the learned judge in the judgment which is, my lord, before your lordship under challenge in this appeal,
Yes.
the learned judge, my lord, said, just, my lord, may I tell before lordship without going through, the learned judge said, while delivering the judgment, my lord, they came to a conclusion that first of all, the civil procedure code is not applicable in red jurisdiction, which is, my lord, we do not agree.
Rule 53.
Rule 53, as well as there are several judgment of the apex code. Rule 53, my lord, yes, of the appellate side rule 226 matter. Second thing, the learned judge said that this is a mere technical point we raised before the court, that in a writ petition filed by these writ petitioners in their independent writ petition, while despite being the fact that they prayed for interest, but the court denied that, then res judicata point which we resorted to, that is a mere technical. We also do not agree to that. That the res judicata point is not a mere technical point. This is our solid defense over the, my lord, the state is concerned.
Let us now go
My
through the
lord.
order.
No, my lord, the order is lordship.
Give us
My lord, 200.
2 minutes time. We
My-
have the memo with us.
My-
Just 2 minutes time. Take your-
My lord.
Yes.
So, my lord, the most parts of the judgment, my lord, that is, my lord, the referred to my lord, that judgment delivered in special bench in Abdul Gori 2019. It is recorded that yes, in paragraph 48, the petitioners therein
They consider
they considered that they would not claim interest.
they are not claiming interest or
They are not
withholding.
claiming interest. And at the same time, it is an admitted fact. It is, my lord, it is reflected in the impugned judgment of the single.
The point here is very simple. There are two things one has to be understood. Some of the writ petitioners who did not approach the court for release of the pension from the date of the superannuation earlier and approach for the first time after the Abdul Ghani's judgment is delivered, they stand on one. Then a petitioners who earlier approached for release of the area along with an interest, writ petition disposed of, directing the area pension to be paid from the date of superannuation without
Interest.
recording any interest. These are the two categories of the cases one has to. I do not know in this case whether I can segregate these two categories or all the writ petitioners comes in one category.
Just a minute, Lordship. সবাই আর ইউ শিওর সবাই সবাই আব্দুল ইন্ডিপেন্ডেন্ট মামলা করেছে এই স্বপন চক্রবর্তীর মতন এবং আমাকে একটা লিস্ট করে দিতে বলুন।
You say some of them, that's why I'm asking. You use the word some of them. Or majority of them. Use the word.
My instruction that all. But they can also say, so far these factual aspects are concerned, my
This
instruction.
is the only point.
This is the only
Suppose
point,
the
that
person-
whether segregated or
person-
not.
There
Yes.
are two things. Suppose the person who did not approach earlier, approach for the first time with this writ petition after the Abdul Ghani's judgment,
Yes.
and then claimed for
Interest.
the interest.
Then whether that
Whether
point is
res
applicable,
judicata
is
or
applicable
order
to them or not.
Whether it would apply, I believe you will not argue this.
Yes.
Neither the res judicata would apply, nor order to rule 2 applies to those writ petitioners because they did not approach.
They did not. Yes.
Only argument against them you can argue, which I believe is that what would be the effect of the Abdul Ghani? They have decided a particular issue,
Yes.
whether that is conclusive and forecloses any issue relating to the interests. That's the only thing you
That's
can
only. That's only. Yes.
on the basis of Abdul
My
Ghani.
my lord.
Other category, you have not only that point, but also res judicata or order to rule 2.
Yes. These are the 2 points.
Are
These are the 2 points.
point of law, straight
Point
away
of law.
argue.
না মানে সোফার মানে এটা তো
Dwarkanath judgment has been relied upon by them.
আমরা কি একটা চার্ট করে নিয়ে আসবো এখানে যে কেউ বাদ গেছে কিনা
Very simple question.
ওরা কি Yes.
টোটাল 10% ওষুধ খেয়েছিল প্রথম রিপিটিশন করেছিল
মাইলর যেটা বলছে যতজন পিটিশনার্স আছে যাদের আমরা এখানে পাঠিয়ে করেছি তারা কি সবাই ইন্ডিপেন্ডেন্ট রিড করেছে আব্দুল গনির পরে ইচ এন্ড এভরি So that-
বলুক না ওরা ডিনাই করুক না
my instruction is that all now
Points are, you argue things
yes
straight away.
yes
The effect of Abdul Ghani,
yes
judicata, order to rule 2. I
Right.
think beyond that you can't.
beyond that
So, it's the law. What is the subject? What is the law of this subject?
yes. No, my lord, না না বই লাগবে না এর পরে দিচ্ছি But may I invite your lordship, my lord, to that particular paragraphs of that special bench judgment?
That
Yes,
is what,
my
for the first point.
my lord. Now, my lord, judgment, my lord, the judgment delivered in 2019, that is, my lord, at page 148. At page 148. My lord, it's a very longest judgment. Now, my lord, if your lordship, my lord,
Not afraid of reading that.
I know that.
দুটো প্যারাগ্রাফ রেলেভেন্ট
First, tell us what is the point of reference and tell us how the reference is
Yes,
answered
yes.
straight away.
My lord.
There must be a formulation of the point of.
My lord, kindly come to page number 150.
150.
150. 150 is the, my lord, the discussion on the earlier special bench judgment and my lord, the what, my lord, made, yes. 138.
সেকেন্ডের রেফারেন্সটা উল্লেখ করেছে ইস্যু ছিল।
I was just trying to find out the reference.
I get you. Page, your lordships, 38 of the paper book of the Abdul Ghani's judge. Abhijit Boyto, sorry. Page
No, Abhijit Boyto was the earlier one.
that's the point of reference.
That is not a point of reference. Point of just I wanted to know.
Lord, page 38, your lordships kindly consider paragraph 9. Running page 38 of the paper.
Earlier reference. Reference before the first special bench.
Paper book or stay petition?
Stay petition, that's it.
Stay petition.
Point of reference, the point of reference is internal page 15 of Justice Darto's judgment, second Abdul Ghani. Page 162 at the bottom. That is a point of reference.
160.
Whether in terms of the order of the full bench dated 16 July 2000 in the full bench of this in Abhijit Boyto,
Yes.
a willing employee who exercises option and is otherwise entitled to pension would be entitled to pension payable from the date of the retirement or pension from the date he makes the refund of the amount received by him. This was the point of reference in this
Mine.
Abdul Ghani.
Mine.
Now, how it is answered? This is what I say. The point of
এটা নিয়ে তোর পেপার বুক দিয়ে
I think, my lord, it starts from page 177 at the middle and the sentence starts in other words.
point of reference must be at the last.
না ওখানে discussion চলছে তো। That is at page 55 also. Paragraph 55. And clarification made.
Paragraph 55 is the answer
Yes.
of the judgment.
Yes. Issue this clarification to that in terms of paragraph 77 of the said order, that is the earlier order, an employee has opted for the pension cum gratuity scheme within the time frame fixed in the notice dated June 13, 2014, and has also refunded the quantum of money that was notified to him. He or she shall be entitled to be paid pension on the date of his retirement on superannuation in accordance with the provisions in the DCRB rules.
What the answer is that he is entitled from the date of the superannuation.
Minus. Now, my lord, so far the interest quantum is concerned, and my lord, at paragraph
Look at it. This is why
48.
Paragraph 59, that the special bench does not decide the matter. That's why he reverted all the writ petitions to the respective courts.
Yes, all pending writ petitions may be adjudicated by the relevant benches, bearing in mind the clarification or correction by the of the said order herein before is made. Now,
Oh, there is another enlightening observation.
page 178.
Paragraph 56.
Yes, before parting, there is a need to make a position clear. There have been decision of single bench division bench in the interregnum based on views contrary to the clarifications issued above, as well as the correction that has been made in paragraph 77.
There has been a contrary view expressed
Yes.
by several single bench and the division bench. Then what is it?
With regard to the paragraph 77 of the earlier, my lord,
Read the second sentence.
if the orders of such benches have attained finality, this clarification issued by this bench would not permit reopening and revisiting the decisions taken by such benches. That means, my lord, it will help me because of the fact that in most of the cases, my lord, before that bench, it reached finality with regard to the interest.
That's why I invited
Yes,
your
my
attention. You were skipping.
Sorry. Yes. And my lord, it is
What about the interest component?
it is fortified interest component at page number 178. Last part of paragraph 48. Well, it starts sentence start.
To put it plainly,
It is noteworthy. Right hand side sentence in the middle start. It is noteworthy
it is noteworthy
that the employees expressed their willingness to refund, which was recorded in paragraph 75. There is the earlier judgment, and they did not claim interest on the arrears of pension. Hence, such interest was not awarded.
No, that was the position there in the earlier judgment.
Position there in the earlier judgment.
To an earlier special
No.
bench judgment. That is a
My lord, before coming to the conclusion in this judgment,
but that was not answered.
yes, answered in this way, the court failed. The court expressed that it is noteworthy that employees express their willingness to refund, which was recorded in paragraph 75.
That is Abhijit Poito.
Abhijit Poito. And they did not claim interest on the arrears of pensions, and such interest was not awarded. Then to put it plainly,
What is there? To
yes,
put it plainly, the balance was struck
yes,
by ordering payment of pension according to entitlement without there being an order of awarding interest.
yes. My humble submission, my lord, that reference to this, that means
It
that
was unwarranted.
in the present case also,
Is it not an obiter?
not that obiter dicta.
Because the point of reference was something else. Observation is out of the context.
My lord, my humble submission, my lord, it is not an obiter because of the fact.
What they have just indicated, what is the point of reference? There was no question of any interest to be component to be gone into.
No, my lord, may I tell, my lord,
If something is done,
my lord, may I?
Whether this was so warranted that unless such observation is made, it will not complete the judgment or answer. Then sometimes the obiter may also bind. But it is absolutely out of context and nothing required. The answer can be made very safely without it.
My humble submission is this. The question is with regard to the, my lord, the payment of pension entitlement to or my obligation to pay for a certain period. That is the question. Now, my lord, if that is, my lord, answered in a positive manner, that yes, they are entitled to, then, my lord, my humble submission that the answer to that, without, my lord, any whisper with regard to interest, that is, my lord, the consequential benefit. Let's kindly consider one thing. The main relief, my lord, is being answered in a manner, and even, my lord, referring to this earlier paragraph 77, but no consequential benefit.
That will relate to order 2, rule 2.
Yes.
That will relate to order 2, rule 2. But here, when you say that in this judgment, the right has been completely foreclosed to claim interest. To that, I have some doubts. I have already populated my views there. It was not. Does not appear to me that it has been foreclosed or completely shut the door.
My lord, kindly consider one thing. My lord, Otherwise, my lord, lordship, kindly consider one thing. It's a monetary claim. Lordship, kindly consider one thing. Something adjudged on monetary claim. Now the principal amount awarded, that yes, this is the principal amount to be awarded by the judgment debtor to the degree holder. But no whisper about the interest. Then whether, my lord, that amounts to
Yes, sir, I am saying that.
yes, order to
Then
yes,
order to
order
rule
to
or explanation 5 to
explanation 5.
explanation either 4, explanation 5, or explanation 6 to section 11.
Yes,
Whichever the situation comes,
yes. Now, my lord,
the
exactly.
plea which could have been taken, having
Yes.
not taken,
Yes.
shall be deemed to have been taken in the
Now,
other
my lord,
precedent. That's an explanation 4 to
exactly our case is
constructive
this.
judicata.
Exactly our case is this, that the division bench, while awarding this,
But I am on a first point. Whether the special bench in Abdul Ghani has in clarity held that they are not entitled to interest.
No.
If that is the position which you are arguing, if that being the position, no difficulty. Then res judicata, why will go? Special bench judgment, higher quorum, may I say, not quorum, is binding on a lesser quorum. No difficulty.
no, my lord, the
But
in
I have
fact,
to understand.
in fact, my lord, it appears from this lengthy judgment, my lord. In fact, the special bench refused to pass any order.
That's a mere observation. It is not a decision. That is what is. That's why I say this is an arbiter in that sense. Because it says that by virtue, since they did not claim any interest therein, so a balance was made for payment of the area. That's the observations. Unwarranted. Beyond the scope of reference.
No, my lord, my humble submission, this is
Because
not
the
an.
scope of reference was whether they are entitled to
That is true.
pension from the date of superannuation
That is true.
or from the date of the refund.
That is true. But
There was no question of any
but
interest to be coming.
automatically, perhaps you kindly consider,
No question.
automatically it comes to consider,
Can
when
that
it's a, my
reference
lord, the claim for money claim.
again asking, sir, so far as arbiter part is concerned, one has to see that whether the point of reference can be decided without that observation or cannot be decided without such observation. If the second one is the correct, then this arbiter is binding. Maybe out of the context, but it is binding because it is relevant for the purpose of answering.
Yes.
But if it is not, the answer to the reference can be easily made without it. Then it is a mere observation.
No, my lord,
Out of the context.
no, my lord, it appears from the several, my lord, the paragraphs of this judgment that the court did not want to leave it for another.
Then exceeding the point of reference. Now, then another question comes. Special bench, which is constituted to answer the reference, can the special bench go beyond the reference?
Well, my humble submission, my lord, it is not.
After what judge's judgment, I am
Yes,
reminding
yes,
you.
yes. There are
Where in
judgment.
case of one demand rules, the reference, it says that it is irregular, illegal reference. I mean, the wrong reference should not be decided, remitted. So anything done beyond the point of reference, no, cannot.
Well, my humble submission, my lord, my lord, I have to go it again with this, my lord. But to the question today before your lordship is whether it is an, my lord, my humble submission, that whether it's an arbiter or whether it was, my lord, the part of the decision-making process.
Your first contention was that in Abdul Ghani, actually the special bench has ruled out any claim of
Interest.
That was your.
Yes.
And probably you are relying on this observation.
Yes.
Of Abdul Ghani.
Yes.
Then ancillary or a point of, I say pop up now, the generation they use this word. We say it's an offshoot or offspring from there, sprung from there. We call it. Now they say pop up. They call it. So is whether it is an arbiter and such an arbiter which binds or which does not bind the court. That's the ancillary one.
Ancillary.
I didn't notice this. So that's why then I have to answer this also.
No, my lord, my humble submission, my lord, reading all these paragraphs, my lord, that with regard to that, my lord, denial or my lord, without any expression regarding interest quantum on that, my lord, the principal sum to be judged by the authority concerned on the basis of this judgment. That means, my lord, it is, my lord, it reached finality. It reached finality because of the fact that, my lord, it follows the earlier judgment also. Because if I say so, that this, my lord, the reference to the special bench and, my lord, continuation of this proceeding, my lord, this is not a, my lord, if I say so, that this is not such an independent proceeding. This is a proceeding started for the purpose of clarification of the earlier judgment. So the proceeding that was started in that, my lord, in 2013 and ended up by that delivering judgment. This is, my lord, a continuation. And there, my lord, the interest And just 146.
Yes. Yes.
My lord. My lord, I just place my lord 2 or 3 paragraphs of my lord it is reported on this issue. Res judicata applicable in my lord read jurisdiction, my lord 2013 5 SCC page 252. 2013 column 5 SCC page 252 paragraph 31, 32, 43. 2013 5 yes.
Yes.
So far as page number 130 is concerned, 138 is concerned, it has been, it is the judgment passed in connection which matter?
It is my lord the judgment delivered in my lord in the my lord the first read. Paragraph 31.
Second round of
Yes.
May I just my lord hand it over lordship the 2013 5 SCC. My lord, kindly straightway comes to my lord paragraph 31 and onwards. Paragraph 31, lordship. May I read out, lordship?
Yes.
The learned senior counsel reiterates that the claim made.
I can read faster than
My,
you. Don't-
yes, my lord.
Just give us.
My lord. 31, 32. And lordship, kindly have a look at paragraph 43 also. When matter reached to finality.
Yes, I got it. You say it's not a technical rule.
Yes.
It's a rule based on the policy, and therefore, once the court has decided, the only exception carved out in Madhya Pradesh judgment of the Supreme Court is that the decision was rendered by a court having lack of inherent jurisdiction.
Yes. Otherwise,
Otherwise,
that's the exception.
it will apply.
Now, my lord, on this point, there's another judgment, lordship kindly noted that 2019, volume 13 SCC, my lord, page 42.
2019 volume 13.
2019, 13, volume 13 SCC, page 42. The paragraph 35 and 44.
35 and
Paragraph 35 and lordship 44. paragraph. No, sorry, my lord. Paragraph 8.8 to 8.11. Sorry, my lord. Paragraph 8.8, 8.8 to 8.11. Sorry. Very sorry. Here. 8.8.
Yes.
So, my lord, on this point, my lord, these are the judgments, and my lord, these are the, my lord, I can say, my lord, the principle enunciated by the Honorable Supreme Court, and at the same time, my lord, I want to place and or my lord refer my lord's own judgment. My lord, my lord, so far that order to rule 2 were concerned. Very recently, my lord, this bench was kind enough, my lord, to deliver a judgment. And my lord, agreeing with the, my lord, the order passed by the single judge on this point. Only, my lord, the different facts was there, or the facts different was there. There it was not prayed, that is other explanation. And here prayed but refused. Yes.
Order to rule 2
Order to
is
rule.
only applicable.
Order to rule
that
applicable.
A relief which was available at the time of instituting
Yes.
an earlier proceeding,
Yes. Did not obtain leave.
having not prayed for, in absence of any leave granted by the court, it cannot be claimed in a subsequent proceeding.
Because it is the principle of order to rule 2 that all your claims should be made against a particular defendant at a time. Here they have made but refused, so no order to rule 2. Here is no order to rule 2. Here section 11, that is, my lord, the explanation 5. So I'm not. That only thing that all these are applicable in the writ jurisdiction. Constructive res judicata, all these are applicable.
And my lord, that's enough for you.
And my lord, another thing, Lord. See, my lord, yes, my lord, in the impugned judgment, my lord, this, my lord, particular point was raised, but my lord, the learned judge refused.
Yes, said it's a technical rule.
Yes.
It's not a, it's a procedural aspect.
Yes.
Not a substantive law.
Yes.
To come in the.
This was
that you have said it's a substantive.
Substantive law. Substantive law. It's not the procedural. Now, another point. Now, may I come to one, the factual problem, that is, with regard to the submission of claim. Now, suppose in 2019, the second special bench judgment delivered and clarifying the earlier judgment of the special bench, and the right accrues again. But the right accrues.
Special bench has said that whatever has been decided has attained finality, cannot be reopened.
Cannot be reopened. Now, the interest quantum is that, my lord, suppose if, my lord, I am, my lord, in a remote, my lord, I want
On
to say.
equitable principles, I tell you very
Yeah.
frankly, you have no claim. You could seek a refund with interest, but will not pay settlement with interest.
My lord knows better than me that, my
On
lord.
equitable principle.
Yes, but my lord, when there is a conflict between a law and equity,
The equity
the
will
law
be
shall prevail, my lord. I'm grateful to your
conscious.
lord. I'm
Conscious.
I'm
That's why
gone.
I say on a equitable
On it.
principle.
Well, if that is so, my lord, then, my lord, these are the all, and, my lord, only thing that there's a, my lord, the practical thing also, that somebody comes, my lord, 3 years after the second judgment, and they say that please give me my interest for all those 3 or 4 years. This is the all. My lord,
So
this is all.
It
basically,
all is a discretion of the court.
Yes.
The delay really is perceived as a discretion. If the court finds sufficient explanation, no difficulty.
No, another thing point is that the learned single judge said that interest be paid from the date of that, my lord, the Abdul Ghani case, from on and from that
From the
date.
date of superannuation, immediately from the next day.
No, so far no interest from the date of the special bench, second special bench judgment. Interest from the date of that means from 2019. Now, my lord, somebody may come in 2020, some 2023, some 24. They come and, my lord, they fill up that procedure and they say that give me interest.
that is prior to their retirement.
No, from the date of 2019. Now, this procedure they have not followed immediately. They, my lord, they accelerated the procedure after 4 years from 2019. And now they say, they're very good. On the basis of this judgment before your lordship under challenge, now give me interest. So my only submission is this, my lord, interest is not at all payable in terms of that, my lord, special bench judgment, as well as, my lord, on the basis of this res judicata issue. Now, these are the all.
Would you lordships kindly take up the list of dates? Because dates are very vital, because this was the leading matter, probably Swapon Kumar Chakraborty. Was very only 2.5 pages list of dates. Well, 16 June 2013. Reference to page reference. This was date.
The director of pension. For the
Dated, this is judgment dated Ovijit Boiddo of the special bench, July 16, 2013. My lord, because of the conflicting decisions, the issue that was referred before the Honorable Division Bench, I just read out page 35 of your lordship's stay application. This is the original judgment. Paragraph 2, page 35. That's also what was the issue before the larger bench. Reference, rather, your lordships. No, not in, yes, Boiddo. Page 2. Now, here there was no question of interrence reference at all. Now, paragraph 73 and 76 was the relevant. 74, 76. 74, 76, if 77, in 3 paragraphs. If your losses kindly let us paragraph 74, 76 and 77.
Page?
Page, your lordships, 73, running page 73. internal page might be 59.
Yes.
Well, paragraph 74. Thus, we answered the 5 questions in the following manner. An employee who has opted for the revised pay scale under ROPA 90 becomes entitled to pension and gratuity by virtue of operation para 17 of the ROPA 1990. It was not necessary for him to exercise fresh option as per memo dated 17th December 1991. Well, this was the first view of the Honorable Mr. Justice Bhaskar Bhattacharya in the single bench, which was applicable to employees who had not opted for ROPA 1990. Benefit of pension cum gratuity was conferred due to acceptance of the reduced age of superannuation of 60 years under para 17(1) of ROPA 1990. And his right for pension cum gratuity so accrued could not have been taken away retrospectively by substitution of the provisions of para 17 in 2007 or by substitution of para 13 of ROPA 98 in 1999. Then, once option has been exercised under ROPA 1990, a person cannot be subjected to the rider of the option exercised under DCRB scheme 1981, as the invitation of the option under the said scheme was with respect to employees who elected to continue in service till the age of 65 years and to have the benefit of the old scheme. For such employees, opportunity was given to submit fresh option as per memo dated 16 December 1991. The amendment made in para 17(2) of ROPA 1990 on May 16, 2007 cannot be said to be valid piece of law. As such, provisions cannot be substituted with retrospective effect to take away the rights already accrued to employee. So as to validate the provisions of para 17(2) of ROPA 1990 as substituted, it was necessary to invite option for switching over to pension cum gratuity from CPF cum gratuity when the substitution of para 17(2) of ROPA 90 was made on 16th May 2007 with retrospective effect. Para 13 of ROPA 98 as amended on July 13, 1999 cannot be said to be valid in the eye of law, as it has the effect of taking away benefit conferred by para 17(2) of ROPA 90, as the ROPA 1998 was made applicable to the employees who opted for ROPA 1990, and the benefit conferred could not have been taken away by substitution of provisions contained in para 13 of ROPA 1998. It was clearly arbitrary and an unreasonable exercise of power, and to treat it as a valid and illegal, it was necessary to invite fresh option under the DCRB scheme 1981 for switching over to pensions cum gratuity, as the provisions had been amended drastically, which could not operate to the prejudice of the employees in whose favor a right to claim pension cum gratuity had accrued. The substituted provisions of para 13 of ROPA 1990 failed to qualify Wednesbury principles of reasonableness, and the action was in utter violation of fair play and justice. In our opinion, after substitution of para 13 of ROPA 1998 on 13 July 1999 and para 17 of ROPA 1990 on 16th May 2007, in order to save the provisions for the vice of arbitrariness, it was necessary to give an opportunity to the employees to submit fresh option under the DCRB scheme 1981, as the option exercised earlier in terms of DCRB scheme 1981 was made applicable. It was necessary to give fresh opportunity to exercise option for switching over to the pension cum gratuity, and the state could not have acted to the detriment of the employees opting for ROPA 1990 who choose to the rider of reduced age of superannuation of 60 years under the para 17. In our opinion, as there was a drastic change of the provisions of para 17(2) of the ROPA 1990 made by substitution in 2007, and ROPA 1998 was interfered with the rights conferred upon the employees under para 17(2) ROPA. All the employees who opted for ROPA 1990 ought to be given fresh opportunity to submit option to switch over to pension cum gratuity. Coming to the relief to be granted, it is clear that some of the employees are in service and some of them have retired, and governments are on record that they are ready and willing to repay the amount of the employer share contribution with CPF together with interest and additional interest. Well, that was the condition, interest and additional interest, as option had not
call for them to switch over to the pension cum gratuity while substituting para 13 of ROPA 98 with effect from 13 July 1999 and retrospective substitution of para 17.2 with effect from 6 March 1990. We direct the state government to give opportunity to all the petitioners and other employees similarly situated to submit option to switch over to pension cum gratuity by issuing public notice or at least 4 newspapers having wide circulation in the state. And then malad another circulation. Now vital paragraph 77. If an employee exercise option, he shall be entitled to pension cum gratuity in accordance with law with effect from the date is refund. Malad pension scheme conceives I am entitled to the pension from the next date of retirement. This judgment recorded refund. What the state started acting when I gave this refund within the meaning of this judgment, they started giving my pension from the date of refund without giving me any area. Clear to your lordships? So a chunk of employees or most of the employees was going to lose at least 4, 5, 6 years pension. But they have refunded the money with 8% interest and 2% more additional interest to form the corpus for pension. Now, your losses, what happened in this case, my lord, Swapan Kumar Chakraborty, your losses kindly come to list of debts. Following this judgment, my lord, July 16, 2013, state government issued notification on June 13, 2014. The state government issued a notification inviting option from the teachers to switch over to pension cum gratuity. My lord, it almost your losses an year after a year. Then August 22, 24, petitioners exercised option within the time limit, the Swapan Kumar Chakraborty, and refunded the entire amount with interest and additional interest. Now, February 23rd, pension payment order was issued, 2015, sanctioning pension from the date of refund. His date of retirement, your losses in 20, date of retirement, just when I'm giving the date of retirement, from the date of refund, kindly see. Therefore, he is losing the pension from the date of retirement till the date of refund. Now, he moved, my lord, the next page, he moved the writ petition, praying for pension from the next date of his retirement and to release area pension together with income. My lord, the division bench, special bench judgment standing as a block. Now, in the meantime, after filing the writ petition by Swapan Kumar Chakraborty, after Goni's judgment came, which clarified, this is a clarification application, clarified, no. How could it be? This is we said, I think the caustic remark has been passed against the state by the special court. That this is absolutely wrong on your part. You ought to have read the judgment between the lines. You can't say that a person will not get the pension from the date of retirement after refunding everything. Then, my lord, after this judgment, when my matter came up for hearing, the Honorable Justice Sinha disposed of, please come and act in accordance with law. Then another revised pension payment order was issued in 2023, March. The judgment of the Justice Amrita Sinha, Honorable Justice Sinha, in respect of the 2015 writ petition was passed in 2022. And the Boyd's judgment, my lord, came in 30th September 2019. Now, your lordships kindly see, therefore, even if your lordships go by the judgment of the Justice Sinha in 2022, it at least, my lord, the revised pension payment order with payment of, my lord, areas should have been passed within a month or two. Within a month or two. They, my lord, what they did, revised pension payment order was passed, my lord, on 19th March 2023. After 1 year. Am I not entitled? This is a question to myself, my lord. Am I not entitled to pay an interest? Suppose your lordship proceed on the basis that I conceded that I will not claim any interest for refund. That's one aspect. But I give you the refund. I am not claiming in the return. You pay with folded hand and give me the money in the next within 1 month or two. You kept me waiting for years together. Now, suppose your lordships, after the judgment of 2019 of Boyd's, even irrespective of my pendency of the writ petition, they ought to have revised my pension payment order. There was no hurdle, my lord. Am I clear to your lordships? Abdul Ghani's judgment, 2019, my writ petition pending. Please give me pension from my date of retirement with arrears. Malad, I paid for interest. I am not entitled according to Goni. If your losses hold that, I'll argue on that also. It's effect of that. But you could have said, look, I'm paying your arrear pension without interest in 2019 itself. Why you kept me waiting from 2013? Then, my lord, the second writ petition comes. Give me the pension, my lord, interest after this 2013 order, either from the date of the order of the Abdul Ghani or from the date of writ petition of mine. This is not, according to me, covered either by order to rule 2 or your lordships any of the explanations. Because this was not the subject matter of the earlier writ petition. Because when the earlier writ petition moved, Goni's judgment did not come into picture at all. Did not come into picture at all. This is the factual background. Now, your lordships, kindly see the Justice Ghani's judgment your lordships has gone through. This was also not an issue. This was only clarificatory application. That it should be effect from the date of refund or from the date of retirement of the respective employees after refunding the entire amount. So this was hardly an obiter. It cannot be, because without this, the court could have passed that on clarificatory. It was not necessary for the court to delve into this part of the order. So what the state is doing, unconscionable game on the money of the employees. You just took advantage of a, if I say your lordships not an erroneous writing of the judgment, it at best your lordships say from the date of the refund. You have to say, well, date of the refund means as soon as I give the refund, I will be entitled from the date of my retirement. The next date of my retirement, according to law. That should have been, this should have been the stand of the state. The state doing this all for the years together. Now the employees are coming, that I have paid you 8% plus 2%, having been retired. And you are embarking upon my money, and you will not give any interest even after Ghani's judgment. This was the issue before your lordships. So, my humble submissions, your lordships, this is neither malediction or order to rule 2, because I didn't conceive with your lordships. That's why, my lord, paragraph 17 and 29 of the judgment I will be placing your lordships under appeals. Kindly consider this. Only 2 paragraphs. Paragraph 17 and 29.
17 and 29 of which judgment?
Judgment under appeal. Judgment under appeal, page 224. Everything was argued, my lord, with clean breast. Everybody was opened all the cards to the learned single judge. There was no suppression, nothing. Paragraph 17. This should therefore cast an automatic responsibility of the state to immediately after clarification on 13th September 2019 in Abdul Ghani's matter to issue PPO. That was my submission before the learned single judge. Irrespective of my earlier pendency of the writ petition, you could have come up and say, I'm giving your pension. This should be the attitude of the state. Because I have done everything on my part. But you have not released my arrear pension for how many years? Date of retirement?
April 2010.
Malab, kindly take note of the date of retirement of this, 30th April 2010. And I have been given that refund 2013. 2013.
Date of retirement?
30th April 2010. So I am entitled to pension from 1st May of 2010. So I am being, my lord, irrespective of any case, I am being deprived of my interest from 2010 to 2013. Now, your losses apply the judgment of the Justice Ghani as an obiter dicta, though, according to me. Apply it. We have also, my lord, I am not say that we have not accepted it. We have not claimed it. What we are claiming, that please give me the interest after Ghani's judgment. You can't withhold that. I have, my lord, said that I am not.
So far as judgment of Justice Sinha is concerned, it came to be passed on 9 February 2022.
Exactly.
And according to you, revised PPO with effect from the date of your retirement was given on 9th March 2023.
23.
Yes, I am saying that. So for that portion, you are seeking interest.
No, I am seeking, my lord, from the judgment of Justice Ghani. Or at least I am entitled to that. If your losses goes all throughout against me, At least I am entitled to that 1 year. This is not covered by Justice Gani's judgment, observation, or obiter, and cannot be, my lord. That's my first point, irrespective of tendency of my 2015 writ petition. When the Justice Gani's judgment came into picture, my writ petition becomes rather, if you'll also say me, infructuous. Whatever, because what I claim, give me my area with interest. So after Gani's judgment, the state ought to have come up and paid me within 1 or 2 months. That's the decision of the learned single judge. And that was my argument. Paragraph 27, your losses kindly consider that. These should therefore cast an automatic responsibility on the state to immediately after the clarification on 30th September 2019 to issue PPO and pay arrears within a reasonable time, a month or 2, at best after the said decision. This was not done. PPOs were issued only in March 2023. Even losses take that date after 4 years. And payment made soon thereafter. And kindly see. Now, your losses kindly come to page 229, running page of the stay application, paragraph 29 of the judgment under appeal. In the instant case, it is firstly seen that the payer for interest in the area of pension post the refund has not been specifically made by the retired teachers in any of the writ petitions. That's a specific case of ours before the learned single judge. That has been disposed of. The said teachers have already given up a claim for interest from the date of superannuation till the date of refund. But scope of the obiter dicta, whatever your lordship say, observation, was for only for that period, not after that. If your lordship construe that it is after that, then the state will pay my arrear after 10 years and I will not claim any interest. And you have taken my money with interest and additional interest. Is it not an unconscionable game by the state? By the payment of the retired teachers? And the said teachers have already given up a claim for interest from the date of superannuation till the date of refund of the portion of CPF. The state, on the contrary, has been unfair and arbitrary in not issuing PPOs and making payment after 4 long years. This is what relates to present petition, because 19 and 23rd, after the refund causing immense hardship to the petitioners. But what is the interest here, your lordships? Interest means you have enjoyed my money, but you have not given something. My learned friend is claiming about monetary claim, all that. In pension payment order, there is one judgment. I have not brought all these judgments. Whenever an employee retires from the state must come with a folded hand and pay payment. That's the judgment of the lordship Supreme Court. Make your payment with folded hands. Unless, my lord, of course, I have something done misconduct or some misconduct or something. That's different, because pension is also dependent upon, my lord, satisfactory service, everything. As your lordship, gratuity, pension, everything. So this is not the case. No, I don't find anything, my lord, wrong in the judgment. Your lordship, kindly, my lord, allow them, my lord, let them pay that in. I'm entitled in law. There is no, and the discretion. Suppose my learned friend is doing, somebody comes after 4 years. If it is, my lord, he can show in the petition with proper averments that he could not come up, being a retired employee. He will not be entitled to pay interest. The first question, my lord, according to me, from the court to the state, why did you not make this within 1 month or 2? You are waiting when they will come up before the court and claim interest. Is it the stand of the state that I will come up and claim the interest and they will take the point of demurrer that you have come up 4 years is the money claim? Well, this is a way of looking of this, my lord. of the subject matter of the present
What
situation.
would be your answer? What would be your answer to your adversary's contention with regard to the res judicata, especially when it has been argued that in the first larger bench, the larger bench in the first judgment has stated nothing about the interest, and the second judgment, that is in Boiddo's case, even while answering the reference, the second larger bench has also made an observation with regard to the interest.
But I tell you, lordships,
According to your adversary, the matter has been set at rest, and it cannot be.
I think
It cannot be reagitated on the principle of res judicata.
But absolutely misconceived submission with respect to my learned friend. I am not claiming your lordship on the refund for the period of my retirement till the date of refund. I am making myself clear, your lordships. This is not my claim from the interest on the refund from the date of superannuation till the date of refund. I am saying after the special bench clarificatory order. This is not on reference. It's a clarificatory order of the earlier judgment. From the date of clarification, even you did not pay my arrear for 4 years. I am therefore entitled to interest. That is not at all covered by the observation or your lordship, if you lordship construe it as obiter. It's not covered by that. Because that was the issue, your lordships, that I will not claim any interest, is not an issue, any observation on the refund. When, my lord? When the clarification order was issued. Because probably, your lordship, the one thing might be the Honorable Special Bench was conscious of the point that obviously they are entitled to interest. Because losses from the date of retirement. So anyhow, that was against, asked to an extent, but not after that period. How could it be a res judicata? I'm not claiming that. Res judicata, the point issue raised, decided, heard and decided. What is the issue? This is not an issue. If your lordship want to put it at rest, your lordships can do it. That's one thing. But even then, after from the date of refund till the date of my actual payment, I am entitled to interest. This is not covered by that observation. I clear to your lordships what I am trying to make out.
What do you think that you are not clear?
But
still unclear.
No, my lord, I'm saying I'm not claiming that. They are probably saying I'm claiming for refund. No. Even after refund, even after Justice Gani's judgment, you kept pending my arrear pension for years together. Then I'm entitled. That was it. That's all. Key. Oh, my lord, only one thing. Page 231 of the judgment under appeal, if your lordships kindly see. 35 I have, my lord, place 34, 35 and 36, your lordships, kindly just for your lordships. This court therefore holds that the state was obliged, paragraph 2, page 231, paragraph 34, 35, 36. This court therefore holds that the state was obliged to, at least within a period of 1 month from 30th September 2019, pay all arrears of pensions from the date after the date of retirement till September 2019, which they did not. This is my point, your lordship, argument. The writ petition have considered in the Muhammad Abdul Ghani's decision that they are not claiming interest on the arrears of pension from the date after the date of retirement till the date of actual refund. But kindly see this answers your lordships, Justice Sen's query. How could it be a res judicata? It can't be a res judicata. Then you will say 35. The state was given a concession and the writ petitioners were already put to a disadvantage. That's my argument to our lordships. The disadvantage being the state having user of funds of the writ petition from 2014 till the year of 2019, and the writ petitioners being deprived of the same. In the backdrop of the above and the discussion on the right of interest on the delayed payment of arrear pension, available in this court's order dated 10th March 24, this court holds that each of them entitled to interest at the rate of 8% from the date of. From the date of the period from 1st November 2019. That means 1 month or 2 months after Ghani's judgment. So, whatever benefit have been given, my lord, the learned single judge is given to the state. More than they are entitled in law. Well, that's our submissions to you.
Only reply, my lord.
What you are, I will meet at praying for that. You have to argue. You will adopt the argument of the
In reply, only point is that my lord, the learned single judge, my lord, practically, my lord, modified or my lord, revisited the issue and my lord further clarified by my lord passing that order with regard to that my lord interest portion, and that point has been taken in my lord ground number 17, that the honorable single judge passed an order without jurisdiction and only honorable special bench can modify their own order. That is my lord mentioned. That is all. Get
Yes. All these writ petitions, is only one appeal.
only one.
There are several writ petitions disposed of by a common judge.
Common judge.
So,
But there is a my lord, I know my lord, this point may be taken up or this point may be issued.
why you did
My lord,
not?
my lord, may I tell? My lord, on that issue, my lord, I am also ready to place one judgment if you lordship allow me. Yes.
They have not taken that plea.
But they have not taken that plea. That is why, my lord, I have not, my lord, relied or placed that judgment. Because the earlier judgment was that in case of this type.
Talking about this judgment,
Yes.
I was just thinking because I was having these with many matters.
Yes.
I was under that impression.
Yes.
So only one appeal is preferred.
Only one appeal preferred.
Yes.
Now, my lord, on
Yes.
well, since 1993, that premier tier matter.
What? You have not taken.
They have
My
not
lord, I have conscious.
they
I have not,
taken
my lord,
that
taken. I'm
point. That is why, my
conscious, your
lord,
lordship, that this appeal is not entertained because the one against that's why I tell your lordship this is a leading matter only.
now,
No
my
appeal
lord,
others.
now, my lord, in premier tier matter, my lord knows in 1993 Supreme Court, there was a case,
Council judgment.
PV Council and then premier tier also, yes. My lord. Yes. Now, my lord, the after premier tier 1993, now, my lord, this is a judgment of my lord.
My lord, I had to file 450 appeals
I know
before
that.
Justice Satyabrat Sinha in organize the teachers matter because of this.
Even
Please file one paragraph appeal.
I
But I have not taken consent.
in case of
I tell you, losses, my lord, then the main issue I wanted to be decided by your
my
lord.
lord,
But this affects the interest and life of the.
We will say that since you have not taken.
My lord, I have not argued that.
taken that point.
I'm not keep. I mean, but I have consulted with my.
You have not taken a final.
এটা ওই primary teacher
That's the one I said. That's.
accepting their
But if your losses, my lord, really, I have to.
both the ways it can go.
My lord,
now, my lord, my lord, myself, my lord, took a point before the Honorable Chief Justice against Mr. Ashok De, where Mr. De was, my lord, bound to file, my lord, at least, my lord, 15th memo of appeal. Now, my lord, after that, the latest judgment of Honorable Supreme Court in 2020, volume 2 SCC, page 173. এই কটা গেল দেখুন তো দুটো গেল কি আর নেই এটা না আছে এই তো 2020 ভলিউম 3 পেজ সিসি
এটা কোনটাই দেখাচ্ছে কি পয়েন্ট
পেজ 173 এই যে আমার কাছে একটাই ছিল নাকি দুটো মানে 173 আছে তোমার ও আচ্ছা ভেরি গুড না মানে কাইন্ডলি কাম টু মাই লর্ড paragraph 63
note corner.
to paragraph 70. This point was, my lord, raised and answered by the Honorable Supreme Court that this is not a paragraph 63 to paragraph 70. 173. জানতাম এই পয়েন্টটা উঠতে পারি। Caption is plea of res judicata.
নোট করেছিস এই এগুলো নোট করেছিস, নোট কর, অন্য কোনো মামলায় লাগবে।
63 to 70. Same fact, same reasoning. এখানেও সেম জিনিস হয়েছিল, একটাই অ্যাপিল হয়েছে। এই জাজমেন্টের আগে পর্যন্ত অন্য ব্যাপার ছিল, এই জাজমেন্টটা এখানে এন্ড না
করেছে বলা পিতা দেখবেন সত্যি না কালির আছে তাহলে বল দিয়ে দাও।
পেজটা হচ্ছে 173, 2020 ভলিউম 2 SCC পেজ 173।
2020 ভলিউম 2 2020 SCC পেজ 173 2020 না কথা বলি।
Singh.
I think
63 to 70.
Principle of res judicata by containing the common judgment dated at the passed by the High Court involved 88 petitions which were allowed with the direction. Out of 21 appeal filed, the 88 appeal file হয়নি, 21 appeal Supreme Court বলছে sufficient, বলছে দরকার নেই। এটাই হচ্ছে এক্সেপশন আগের জাজমেন্টের সঙ্গে। Procedural laws, technicalities, and processional law review after years of empirical experience. Ignore about the civil registers, but a common judgment has been delivered in cases in which consolidation order are specifically involved. We think the irresistible that the right simply leads to the entire dispute behind.
Yes.
This is all.
Okay. Yes.
Hit.
Lots.
For the next.
And these are blood applications for addition of party in the pending blood appeal.
I am appearing for the respondent, Lordship.
These are blood applications filed by a non-party blood, the requiring body,
Why is required to be added as the party?
because blood there are provisions.
What are the provisions? The acquisition authority for us.
Uh,
The land acquisition.
Blood there are blood provisions under the Land Acquisition Act, and blood there are judgments where blood they say that because I have a liability to pay,
So that's
the
true.
enhanced compensation blood I have a liability to pay.
To pay as determined by the land acquisition collector.
No, after that in reference before the reference court.
Section 18 reference.
Yes, referee court has increased it. I was present before the land acquisition collector. I have deposited the money.
So
There is a difference blood amount which has been allotted.
why for the first time in the appeal you have to? Why did you apply for your addition the reference court?
I was not informed. I didn't know that there was a reference pending. Somebody must inform. Lord, the provision is that I should be given a notice.
You were not aware that there is a proceeding
No.
which is pending, a reference has been made.
No, I was not aware.
It was before the government, and the government did not.
It was before a reference court.
By the appropriate government.
Lord, land acquisition collector must have been served with a notice, but I was not served with a notice.
Under the Land Acquisition Act, Act 1,
Yes.
it is the appropriate government or competent government who makes a reference under Section 18, not the land acquisition collector.
No, here, Lord, the award against aggrieved by the award, Lord, they had gone before the reference court.
No, they have to make an application before the appropriate government, and the government then refers under Section 18.
Subject to correction, Lord, I think
Look at
Section
the-
18.
Look at the provision.
Lordship, today hopefully the matter is fixed for application, hearing of applications for substitution and
For
set.
an addition.
Lordship, let the matter be heard and substituted first. Abatement be
What application?
removed.
Anybody
Then
has
Lordship,
died?
he will be coming into the picture.
Keep on.
Until and unless the appeal is,
Why substitution and abatement?
Lordship, appellant is not here. I am for the respondent.
No, appellant is this. I think this government has preferred
Government,
land acquisition collector.
They have preferred for substitution and abatement.
Then that one,
Lord,
Act 1.
আরেকটা কপি কপি আছে
পুরনো ল্যান্ড অ্যাকুইজিশন একটা
এই বার কর দিচ্ছি বার করে দিচ্ছে সেকশনটা বার করে দিচ্ছি
It's a collector, and you are not the appropriate
No,
government. That
it's
is
collector.
Under the labor legislation.
Yes.
Yes, collector.
Now, Lord, in so far as the notice is concerned, judgment এনে show দাও দিয়ে দাও 2011 টা দিয়ে দাও হ্যাঁ একটাই দিয়ে দাও হ্যাঁ দাও দিয়ে দাও 2011 volume 2 হ্যাঁ
Yes.
Lord,
The last judgment I've given your lordship, Lord, that is 2011 volume 2 SCC. Kindly take from paragraph 31 onwards.
Last response. Today applicant, তুই এখানে থাক। টাকি করে জানবি কোনটা?
আমাকে নোটিশ দেয়নি
Yes, as he's a requisitioning body, he wanted to be added as a party. That is good for you because now they cannot claim under section 19, no notice.
Lordship, the applicant.
That's good for the,
As per UP Awas, the original order passed by the Honorable Supreme Court, my lord, they have a right of audience before the my lord, land acquisition collector.
that is what I'm saying. They have, but if they say no notices, nothing of that kind, at least here they have a notice and everything will be argued here.
And what about the, my lord, they could have given the evidence before the why price has.
To give evidence.
At this stage, I am only asking for addition.
Uh,
I'm only asking for addition. I am not saying
But
anything
I'll
else.
take the plea, my lord, that LA judge was not correct while passing this order because they did not get the opportunity. I am the appellant. I am the acquiring body.
I thought when you are on the respondent side, I just thought that you are for the claimant.
No.
But I just
I
want.
was
I am supporting.
for your benefit, for the
No,
claimant's benefit.
No.
I just want Lord to be added as parties. After that,
No, it's not so simple.
Lord,
Because the subsequent the plea, I could imagine that what would be taken.
no. Subsequent plea, of course, Lord, that is up to your lordships to allow or not to allow. That's another question. But Lord, as of now, my prayers are only for addition of party.
We may not allow.
It has got a civil consequence. After all, my lord, they would be out of pocket.
May not allow. Even a transferee pendente letter has no right to be added as a party in a procedure.
But here there is a provision under the Land Acquisition Act.
Justice Tarun Chatterjee's judgment of the Supreme Court.
Then, my lord, I'll have to show, my lord, from the act, my lord, the person, interested person comes.
I have seen that.
Well,
2011 judgment is also.
Yes.
What is the person interested?
Lord,
The person who is interested may abandon his right. May twist to his right. May waive his right. Does it mean that he is a person interested?
Let them show that LA judge has issued notice in favor of them.
For now, kindly allow my application for addition of parties.
Have you taken this plea? In the memorandum, you are arguing so vigorously. Have you taken this in your memorandum? You never anticipated. Arguing a point without any ground having taken in the memorandum.
Order 8. I'll come back.
What?
Additional ground at the time of.
We'll have to seek for an amendment. We may not allow amendment.
কোন application for addition of party টা হচ্ছে হোক না এত
So vigorously. The difficulty. It will inure to your benefit.
Lordship, they have filed an application for substitution and abatement, setting aside of abatement of the appeal. Lordship, first let the abatement.
Absolutely, you are correct. If there is a substitution, then that has to be done first.
Right.
And that has, the period has been over.
So abatement, setting aside abatement, any application has come out.
Yes.
Where is that application?
But no delay has been explained.
Let us see.
Can 3, 4, again 3, 4, in connection with different appeals.
We are talking about this appeal. We are talking about this item number 10. Anybody dies?
Item number 10, FAT 136.
136.
136.
Substitution is here. Who died? Original claimant, the plaintiff. Shantimoi Dotto.
Shantimoi Dotto. The names of the
That is the respondent number 1.
Malan.
He died. 2016.
Para 4.
Application is in 2014. This application. There is no section 5 on everything.
Hey.
What is the explanation? There is no explanation for 2
Well,
years.
kindly come to para 5.
There is no explanation for 2 years. Yes, paragraph 5. Please come to paragraph 5. I am putting this question on paragraph 5. Tell me, you had a knowledge on 17/4/2022 when application is filed? 2024, read paragraph 6, 7, 8, 9. Tell me what is the explanation for 2 years. What is the explanation for 2 years? Tell me.
Well, I'll use one supplementary affidavit to explain.
What is this? No, definitely not. So casual exercise on the part of your authority. The casual exercise. Had you not been informed, you came to know of this, I can understand. But you were informed in 2022 by an advocate, and thereafter you were sitting silent, and this application is filed on 3rd January 2025. 3rd January 2025.
I'm aware, though it's not pleaded, the information was given at the time of hearing on 17th April 2022. But who are the legal heirs? Whether they are major or not, those informations were not available with us. So thereafter, we went, we found out, and thereafter we got the names. Then we filed this application. That was the actual fact, but it's not.
Fact, but this is section, the paragraph 5 says something different. Says that they by a letter communicated.
Yes, at the time of hearing,
So,
they have.
Says that this death came to the knowledge of the appellant only on 17/4/2022, as one notice for information was communicated through the learned advocate.
Yes.
On the advocate and record of the appellant. So,
without any death certificate, without.
Not required.
That is not required.
It was given. Everything was given.
Yes, you have the copy of the.
Lordship, I missed it. I have the copy. If your Lordship.
Give it, come.
Yes, 2 p.m. Lordship.
Bring it to.
Yes.
2 p.m. I have.
No, nothing. 2 p.m.
আমার বেলায় খালি স্ট্রিক্ট
Okay, my lord, kindly. I have nothing more to add in my application. But unless this defect is obviously not done.
Lordship, this is the letter.
So, you know,
দিচ্ছেন
no.
No, kindly see, for,
Everything was given. Everything was given to you with the names of the heirs, with the certificate, and everything was given. It was not that it was not given to you. And there's the receipt. What more?
we
What more?
we write sui juris. We write,
What? Not necessary.
we write
Sir,
so many things.
sorry.
But in respect of one person, they did not provide the death certificate. I'm not saying that it is always
Sir,
required,
Sir,
death certificate.
Sir, they have disclosed ষাট বছর, 31 বছর, 35 বছর. What more? Why juris and this has to be written? That is in the application for substitution. You don't know when a age is given. Boys, the boys.
I've checked it up. I've checked it up.
Then what more? 55 বছর, 24 বছর, 31 বছর, 80 বছর.
Sound mind, not given.
Which is required.
Sound mind, not given.
কন্যা, মাতা, পুত্র.
On that basis, on my substitution application.
2.5 years.
Well, then I had to find out whether
No,
they are in sane mind.
in mind.
Well,
Let it be a sane mind. We are deciding this. If you say so, sane mind, then we are deciding it.
Well,
But
for
sane mind.
my lord has taught me
No,
that these are the basic informations for substitution. You need to give these pleadings.
we are dismissing application, holding them. Official procedure like this.
615 days.
I have not seen.
Lordship,
Hmm?
heavy exemplary cost.
615 দিনের delay close.
Acceptable, no?
115 days delay. Matter of
When I'm in that side, even 5 years delay is small. When I'm this side, 615 days delay. We have explained everything. Almost, my lord, I can see.
deposit there. Yes, sir.
Well, 615 days is
2 years. Nearly 364 or 65 days in a year.
Well, I have explained who has declined.
So the deep year.
Well, who has declined to accept the brief? It's not the fault of my client. Who has declined and thereafter everything. I don't want to take name.
But there are certain gaps of say 1 month, 2 months gap. No explanation is offered.
Sufficient explanation has been given.
Then I'm taking you. Please come. Whether sufficient explanation is offered. Up to clause D, no difficulty. There is a symmetry. Clause D relates to 9th May. Clause E relates to 20 July. So from 9th May to 2 months, 9th June and 9th July, you have not what the appellant took steps. There is a complete silence. Then let us see from 12th July, next is 18th July, 31st July, wonderful, no difficulty. 16th August, no difficulty. From 16th August and then 21st, nearly 1 month. When everything was sent to you, the junior advocate went and met along with the land acquisition officer. And then the advice came on after 1.5 months that you have to file Section 5. You are a lawyer. Believable story. And then 21st September, as per instruction, on 3rd of October, instruction received. 18th February, parawise. Why there was a delay? Parawise from 3rd October to 13th February, 18th February. How much?
CD,
November, December, January, February, 4 months. What you were doing? Tell me. I understand days delay should not be explained. Every day's delay, each day's delay. But there must be some symmetry. 5 days, 7 days, 10 days, I can understand that the time is consumed. 4 months, 3 months for such fringe issues.
My learned junior is overburdened with the land acquisition cases.
So it's a very good that she has the large chunk of the matters, but litigant, when it comes, it owes a greater responsibility upon the member of the bar to see that immediately the applications are done. So deposit.
This is not fault of my client. My client would be settled because of the learned lawyer took the time to prepare.
It's a good cause.
For that matter, my client would be settled with cost.
No, it is all your client has given. Please look at it. On 3rd October, as per the instruction, copies of the award under Section 11, notification, report submitted to the senior counsel. But due to non-availability of the records, what he will do? Your client has not provided. Gazette notification, who will provide? The advocate. It's the client who will provide. And the time to time amendment made thereunder, and the copies of the deed referred to in the red report. could not have been produced. This was on 3rd. And then from 3rd October to 18th February, then a parawise statement of events of each of the cases was handed over.
3rd
May-
February.
May 18th, please, from 3rd October, October, November, December, January, February, because the 18th February, 4 months, clear months, start. And then parawise statement, what you were doing for 4 months, substantial, 30 days is the period of limitation. You could not. No sufficient explanation. Not a fault of a lawyer, the fault of the litigant. What to do?
Litigant, malad, here is the government. Litigant,
The privilege litigant?
no. I'm not saying,
Must be treated
but
at
it's
par
a
with the-
collective decision. It's a collective decision. So file moves from one table to another table.
Sir, I understand from these documents, the file has to be moved for documents.
But one officer comes.
Then our judgment is staring at your face, authored by Justice Kaushik Chongro sitting with me. Castigating the role of the government. If you want, I can rely upon that judgment.
The officer who comes and sees the lawyer, then that person has to get in touch with the office. Then office gives the instruction to the district lawyer, and district lawyer gets in touch with the GP. That's how it works.
Anyhow,
And learned GP of that district will collect the certified copy.
certified copy was collected. Everything was with you. Everything you have applied in an earlier.
Not these.
What are you talking
These are
about?
the documents.
The notification.
Notification.
Notification is in our file. Rate
report.
When you submitted, these were submitted by you. There was a deed which was relied upon by this assessor that was available to you. Everything was there in the file. When you handed over the counsel in the trial court to represent and defend, is it expected? What are you talking about? We are going to write this. That once these documents were handed over to the lawyer to be marked exhibit, it is unbelievable and improbable that it will move from one desk to another.
Record keeping is very poor in the government department. One officer comes, goes, gets transferred. The other officer, after 3 years, 5 years, does not catch hold of those documents. It's not that an individual's
24. What you were doing?
Same already হবে স্যার।
Same.
Same. ওই 10 নম্বরের মধ্যে অর্ডার হবে। Same as item number 2.
Same as item number
10.
মানে যেটা হচ্ছে তোমার
10.
136 FAT 136
উনি নিয়েছেন। একটা ট্যাগ নিয়ে অর্ডার করে দিন প্রথমে।
yes got
এটার ট্রায়াল কোর্ট রেকর্ড ফেরত যাবে
সে ট্রায়াল কোর্ট রেকর্ড
যদি এসে থাকে। ও আচ্ছা।
না না তা আপনি বলবো কি ব্যাপার 139 মানে there is no I do not see মানে any substitution এটা আমি বললাম
ওই 11 মতন অর্ডার হবে 1 লাখ আবার একটা 1 লাখ আসছে দাঁড়া।
সবটাই যাবে
My lord, can 4 is for substitution, my lord. While can 3 is injunction application. My lord, the original appellant number 3 died, my lord. My lord, she died on July 22, 2023. 2023. My lord, appellant number 1 and 2 were already on record, my lord. My lord. Yes, my lord. 22, 20. My lord, actually, 2024. My lord, actually, appellant number 1 and 2, they were already on record, my lord. Yes, my lord. And only, yes, my lord, they're the daughters of the appellant number 3. No, but only for appellant number 3, he was not on record. The husband was not on record. For that, my lord, for only for appellant number 3, already on record. They were, my lord.
I am for the respondent number 1, you know. I am for the respondent number 1.
Uh, 23. Yes, my lord. My lord, Mr. Indakhabalam Meena, he's an advocate on record, my lord. Yes, sir. Yes, my lord. Yes. Yes, my lord.
Lordship, in respect of the other applications, Your Lordship, we have not been served. We have only received, Your Lordship, CAN 4.
My lord, I have served only the same CAN substitution application, my lord.
The
substitution.
substitution
Why
application
you
we
did not
had
serve the application for injunction? The
I shall serve, my lord.
let CAN 3 of 2024
24.
be listed after 2 weeks.
So,
Lordship.
In the meantime, the copy of the said application shall be served upon, you are the advocate and
I'm there
record. What is
for
your good name?
অগ্রজিৎ রায় চৌধুরী।
No, no, can 3 এখানে file করেছি। What is the can 3 is the injunction or addition? না, ভিতরে দেখ। ও, আরে clerk। It's an addition.
And 3 of 2015.
Can 3 is a application for addition.
Whom you want to add?
My lord, I do not have the brief right now, my
The
lord.
third party.
Third party applicant.
Applicant ke.
Anil Kumar Banerjee.
Who is this Anil Kumar Banerjee?
My lord, I have to take instruction regarding that, my lord.
Who is the advocate? দেখো তো কিছু। Constant.
Bhaskar Prasad Banerjee.
Bhaskar Prasad Banerjee. He's the advocate. He's not the advocate on record of the appellate.
My lord, Intakhab Alam Mina is the advocate on record, my lord. Mr. Intakhab Alam Mina is the advocate on record, my lord.
Somebody represented by Mr. Bhaskar Kumar Banerjee has filed this application. You have not filed.
Then, my lord, kindly keeps it after some days, my lord. I shall take instruction regarding that, my lord.
Whatever. Let the sorry we can't because nobody is representing that applicant. Let the can 3 of 2015. No, can 3 of 2015 be listed after 2 weeks.
And in the meantime, your lordship, if they supply us the copy of the paper books.
They are not here. The person who has filed is not here.
Lordship. No, I'm just asking for your lordship the paper books. I think there was a direction to file paper books. They have not served your lordship the copies of the
Paper
paper
book has
books.
been filed.
No, my lord, paper book has not been filed.
Look at it.
There was a direction, your lordship.
Anyhow, let it come after 2 weeks. We'll see to it.
Lordship, I'm grateful.
On the next. Grateful. তোর কাছে চলে যাবে ওটা তুলে নেবে কোনো ভরসা নেই
I think section 5. I couldn't serve them. I couldn't serve them. So, 2 weeks. Kindly posted the March month list. That finally posted in the March month list. Okay. Cheers.
My lord, item number 27, I beg to appear online. My lord, item 27, I am appearing for the appellant petitioner. Lordship, I stand for an apology, lordships are not audible. Lordship, item 27, I am appearing for the petitioner, appellant petitioner. There are, my lord, 2 applications on board. The first application, my lord, the first can is seeking amendment of the cause title of the memorandum of appeal. My lord, this amendment is necessitated on 2 accounts. Firstly, my lord, the appellant, which
Sir,
was
what is the other application?
Other application, my lord, is for amendment of the grounds taken in the memorandum of appeal.
So both are amendment applications.
Yes, my lord, both are amendment applications.
Where is the other side?
My lord, since this seeks amendment of the memorandum of appeal, these applications have not been served on the respondents. I am instructed that in 2013 there was a stay application which was disposed of, and since these 13
have to serve after 2 weeks. Come.
My lord, I shall serve and come back. Very
yes. Next.
Obliged, my lord.
Call the next matter.
My lord, I am for the appellant.
What is this old application of 2000?
My lord, restoration, my lord.
Where?
Restoration. Yes, my lord, I have served, my lord.
Have you effected service upon the respondent number one?
Yes, my lord, I have served everyone, my lord.
No, last order reveals it was not served.
Yes, my lord, after that I have served, my lord.
It is delivered. Actually, madam.
HMR.
Yes, respondent number one was member of the managing committee represented by secretary.
The managing committee, so.
And the added respondent, teacher in charge.
Yes, my lord, I have served.
How much? What is the when it was dismissed?
My lord, it was dismissed long back, my lord. My lord, 25/4/2016, my lord, due to non-deficit of the deposit of the Tolobana fees, my lord.
Have you deposited?
No, my lord.
Why you have not deposited?
My lord, I will deposit it by.
Because you deposit then it was dismissed in Lawajima.
Yes, my lord.
First you deposit, then you was go and deposit, then
My lord, kindly direction may be given to deposit, my lord.
go and deposit the Talwana. How much? 2 rupees.
My lord, 3.75, my lord.
Go and deposit.
My lord, they said the appeal is dismissed. Will not take this amount, my lord. They are not ready to accept this amount.
Where is
শ্যামচরণ ভার্সেস শিবজি বাই 1977 সুপ্রিম কোর্ট করেছে ওইটা হলো wherein the lease had expired by is
application. What is this? What did he 2018 application? What?
No, it was heard by a lot.
Then another learned judge. On the honorable judge.
My submission completed. My letter was-
But it can't be done because my brother was not a party to that hearing.
Let it be 24.
Will be after 2 weeks because he has gone to
কোনোটাই নেবেন মানে কত
adjourn for 2 weeks.
মানে কত টাকা স্যার বলে দিন বাড়ি পর্যন্ত বলে দেবে তাহলে কত টাকা
Let's call the next.
31.
আমি আছি।
Petition.
This is my application.
স্যার আমার
Yes, my
Why it did not appear, sir?
during COVID period on 1st of July 2021, it was
COVID period.
COVID period. I was physically prevented. It has came to Manada. Yes, madam. All are restricted.
All are represented.
Yes, madam. Only restricted.
I am appearing in behalf of state.
COVID period.
Have you annexed the order of dismissal?
Yes.
When it was dismissed, sir?
On 1st of July 2021. I have status report I have given. Annexure
1st July.
Annexure page 8.
So the appeal is not dismissed.
That will be Appearance.
With this application,
I'm application for stay. Well, a stay of the order dated 20th November 2019, my lord. 19, my lord.
one time,
And 1 line is a lot.
2025, sir, stay now.
Stay now, my lord.
Make it ready.
Thereafter, my lord, COVID period, and thereafter, my lord, I
Whatever
had to
the
face,
COVID
my lord,
the code was functioning.
thereafter,
The code was not functioning.
I
Sir, after such a long time,
I faced
it is
my
better to decide the mean appeal.
your lordship, my lord,
You claim to be the organizing teachers.
organizer teacher, your
So,
lordship, my lord,
prayer was not considered by the learned single judge.
my lord, yes, my lord, and my
So there is no scope to pass the order of stay.
no, district level inspection team inspected the school.
By the
My lord,
scope of
my name was there, my lord. My lord, the contempt application, my lord, the district inspector of the school submitted that there is no vacancy. That is wrong, wrong submission. Thereafter, the school authority stated that yes, there is submission and submitted report to the DI of schools. Our earlier contempt application was disposed of. Headmaster submitted report to the DI of schools. Yes, there are vacancies. I am placing.
Facts which you are required to.
Yes, yes.
When this school received recognition,
But your lordship,
1998.
it is a high school or higher secondary school.
Higher secondary.
Junior high school.
Initially it was junior high school. Thereafter, I was appointed.
Please, you are appointed in a junior high school or
no,
after the recognition or prior to
Prior to recognition, he was appointed.
prior to upgradation section, recognition of upgradation section.
Upgradation means high school or
High
class
school,
eight,
high
class
school,
what?
9, 10, 10, 11. Thereafter, 9, 10 and 11, 12.
Hey, so 19
Prior to that, I was.
upgraded. Prior to this, you were appointed.
Yes.
You were appointed.
Yes. My
LIT, the team, I mean, they went for inspection before upgradation. What is the report? Whether you were
report
working or not shown working?
I don't know. As per the order of this honorable court, DLIT was prepared. DLIT
What is playing in our mind is different.
Yes.
Playing in our mind, the Niranjan.
My name was there.
Niranjan's house judgment. Playing in my mind is the Sikona Maiti. Playing in mind those judgments.
My lord, the DLIT inspected the school and my name was included in the inspection report. That I am working in the school.
Only for the reason vacancy was not.
And
He is the organizing teacher.
organizing teacher, yes.
There are two different.
No, as organizing teacher.
One, it says when the appointment is without following the procedure, even if you were discharging the duties, mere upgradation does not mean that you should also be approved. But there is another line of judgment which says that if the DLIT has found that you were rendering services or you have been appointed, then on upgradations or recognition of the school, at least you have a right of an approval. I think Justice Dotto, when he was of court holding the bench, have held no right of approval.
My lord,
Have you gone through a recent judgment delivered by us?
No.
Not my brother was not there last week.
With just Honorable Justice Bishas. No, my lord.
Taking the stock of all the judgments on this.
My lord, what happened? My lord, as per the order of the division bench of this honorable court, my lord, in this matter, my lord, a fresh inspection was done
As
by
for
the
the case I have taken into account, press inspection, DLIT report, whether it was there or not. Justice Bhaskar Bhattacharya's judgment is also there.
and my name was
Have you please go through that judgment unnecessarily? Please go through that judgment. If you come within the exception, no difficulty.
একজন করে দিচ্ছে
এই কবে দিয়েছিলাম এই যে
জাজমেন্টটা দেখে আসতে বল
enter the I'm grateful to Lordship. 7th February.
7 February MAT NAC
Matt नहीं होगा
Matt
Matt number
yes we got it we got it
FMM 1946.
19
of 2018.
1946
I try my level best.
পরশুদিন
Next week matlab next week
next ঠিক আছে
দিয়ে দাও এই না প্লেটে নাও এটা
একজন
প্রদীপ কুমার ঘোষ স্যার
আচ্ছা I'm grateful.
Malad, kindly take it
I'm
up.
for the state.
Item number 33.
I'm for the state.
This is my application for appropriate order. Everything and everything has been annexed in this application. If you also kindly decide the appeal on the next week, then my lord, kindly take it up on the next week, my lord. Monday on school. And he's for
I'm
the state.
secondary board
I'm for the state, Lordship.
For my lord, I am appearing for the appellant petitioner. Lord, this application is for appropriate order for hearing the appeal. And yes, I have no objection. Lord. In the month of June. No, my lord, kindly, my lord, make it, Lord, prior to, my lord, the vacation.
My lord, I have received. My lord, responding authority, my lord, the state.
Yes, I have, sir.
Primary School Council. District Inspector, Murshidabad.
Or I appear for the Murshidabad District Primary School Council, madam. I don't.
আচ্ছা আমাকেও পেয়েছি
কপি আছে গো
কি বলছি
এতে নেই জানো তো
Yes, if they, Lord, do not file the opposition, my Lord, or they want to file, then in that case, your lordships will pass the appropriate order, my Lord, by giving them time. I have no objection to that. Lord, what I am praying, Lord, let it be hard, Lord, prior to, Lord, the summer vacation. Lord, paper book is not required. It has been dismissed, Lord, writ petition on the motion stage. Only the copy of the writ petition, nothing else. Only the copy of the writ petition. That I will supply, Lord. I will procure that, my lord, I will supply. The honorable judge's copy and my learned friend's copy. Writ petition. Huh? No, my lord, the delay has been condoned. My lord, your lordships kindly see the order. Huh? Yes. 2, 3, 4, 5, they do not appear. They are the appellant, my lord. The appellant, my lord, are the writ petitioner 2, 3, 4. 2, 3, 4. So, my lord,
certified copies there, my lord.
certified copy টা দেখো তো 2, 3, 4 টা। Lord, let me check up, my lord. Let me check up. হ্যাঁ ক্যানটা তুমি দেখো না, ক্যানেতে দেখো আর এইতে দেখো তোমার yes, my lord, I will let 4, 5. So, Suleiman Ali. Then, my lord, in that case, in that case, my lord,
While MD Akbar Ali was in the writ petition, he is not in the appeal.
liberty, my lord, to strike out their name.
The first appellant in the my lord, certified copy, kindly have a look. The name is MD Akbar Ali. But
Certified copy.
the certified copy, first writ petitioner is MD Akbar Ali.
Certified
But
copy
in this appeal, my lord, neither he is an appellant nor my lord a pro forma respondent.
হ্যাঁ হ্যাঁ ওইটাতে দেখো না সার্টিফাইড
Yes.
সার্টিফাইড কপিতে দেখো মিলিয়ে দেখো
Or let him withdraw this appeal, my lord, and come with a fresh one if they so desire.
My lord, your lordships kindly give me this leave, my lord, the learned lawyer, my lord, will my lord strike out those names, my lord. After taking ওগুলো নেই, এগুলো দেখোনি তোমরা, চেক করোনি,
শুধু
এই অ্যাপিল পাউদের নামে ফাইল হয়ে গেছে।
এই গোলাম এই জুলফিকার এক্সেপ্ট
হ্যাঁ
আমাদের কোনো কপি সার্ভ কর
Lord, your lord, advocate record is here, my lord. Yes. Bolar.
Aadhaar code
তোমার আমার
দেখোনি ওটা রিট পিটিশনের নাম নেই ও, দেখবে তো, না দেখে তুমি সেটা লিখে দিয়েছো। Your lordships kindly give me this leave, my lord, to strike out those names, my lord, those who are not here, my lord, in the writ petition. Everybody has to be struck out. Yes.
only Zulfikar with the
At the time of moving the section 5 application, the section 5 was allowed. My learned friends were there.
No.
Here, my lord. Not so far the appellant is concerned, those who are not the appellant, their names appeared in the Bokaladnama. That is your lordship. party in the then Lord, the phrase vocalogram should be filed and the names of the persons should be not stuck out. Those were, that is the only solution. The phrase vocalogram obtained, Lord, from obtaining from the clients, Lord, those who will in the Lord read petition. And Lord, that will be for your Lordships, kindly give me this liberty at this juncture, my Lord. কি বলছেন হ্যাঁ তুমি দেখো না আমি কি
দেখছি এখন দেখছি পিটিশন দেখছি
নরমালি ম্যাটগুলো সার্থক আপলোড সেটা
দেখুন কি
আমাদের এখানে সার্ভিস পাওয়া চৈতালি ভট্টাচার্য সরাসরি দিয়েছিল হ্যাঁ সেখান থেকে তোমার কাছে এসেছে এই হিসাবে তোমরা পেয়েছো
দিয়েছে দেখি
liberty to mention, my Lord, kindly in
that has been given not my appeal, my lord. I appeal for the appellate, my lord, led by Mr. Devashish Kundu. Mr. Kundu is appearing online.
My lord,
He's on.
would it be a lordship's pleasure to hear the matter today? Or
There-
if I can appear in person before your lordships tomorrow,
No, Can 1 has been disposed of.
Then why it is showing as pending? Then it should not be shown under the heading application.
Lordship, that's been already because there was
Have you
one Can
prepared the
application
paper
which
book?
I had not pressed, the injunction application.
Have you prepared a paper book?
Yes,
That's
yes,
a
yes.
direction. He
Yes.
must inform your lordship, my lord, kindly sees the order dated 23rd November.
File has not come.
Oh, I'm sorry.
Let us wait.
Own direction.
My lord, please see the order made by the Honorable the Chief Justice,
Yes,
my lord.
my lord.
23rd November 2023.
Oh. Can 3 was allowed,
Lordship.
which was a restoration. Where is Can 1 and 2? No.
But Can 1 is already
Can 1.
passed. So, my lord, the Chief Justice, the Honorable Division Bench, my lord,
The paper book was dispensed with.
my informal paper book, my lord, the order I prayed for, my lord.
Sir, informal paper book nahi. Therefore, stay is refused. The stay petition is retained and be treated as informal paper book. 23rd November 23.
So the application remained pending.
No.
It is treated
only
to
the
be
prayer-
as an informal paper book.
Yes.
And the stay application is retained.
Yes.
Lordship.
As a paper book.
So let the it is brought to our notice that an application being Can 1, the application being Can 1 of 2023.
But only thing, my lord, instead of Monday, may it appear on Tuesday, my lord, and someday. Next Monday. Yes. May it be taken on Tuesday. Lordship. Yes.
Only one thing, may I only pray for your lordships. If your lordships is taken up on Tuesday, next Tuesday, then I'll be in some difficulty from Wednesday onwards. No, from Wednesday onwards.
And by Mr. Kundu, my lord. Or my lord kindly keeps or kindly keeps it after 25th, my lord. Mr. Kundu will not be here, I am told, my lord, from 19 to 25. So may it be on 26th or 27th.
Otherwise, I'll just again make a prayer for your lordships. Your lordship will again get.
Keep it on 26.
Yes, sir. Leave the place. Leave the place.
In this.
For the applicant, my lord, I'm praying for not today, my lord.
What is this application?
My lord,
Can 1?
Firstly, my lord,
led by
Section 5.
I mean, he is not well. He is ill, my lord. He is Swati Day.
Oh, where is the advocate and recording the Gopa Bisa?
She is not there. She is in Supreme Court, my lord, for SSC, ma'am. She is not there.
Last time also we taken ad.
What can be done? Let her remain there. Somebody else must be appointed. Yes, give the file.
Okay. দুদিনের delay আছে। আমাকে বলছেন? আমাকে বলছেন? 48 days এই যে।
Can 1 is for condonation of
What is this application?
My lord, the matter relates to my lord transfer, my lord.
application.
My lord.
Well, there is a section 5 application.
Section 5 has been allowed.
Allowed.
By
It's all right. My lord, my lord.
What is the ground for transfer?
My lord, medical ground, my lord.
Is what you say?
My lord,
Is a primary?
my lord, at
My lord.
Is a primary or secondary?
my lord, it's primary. I am for the district primary school council. My lord, at point of time, my lord.
What is the rule?
My lord, here, my lord.
The rule I am asking you, sir.
My lord, the people's teacher ratio.
I
People's
am
teacher.
asking, is this a case? I do not know whether it
My
comes
lord.
under Rule 4, which has been
Rule
amended subsequently.
Rule 4.
Rule 4A talks about the medical, and the Rule 4E say that the clause C and D will not apply to a case of a medical under Rule 6.
My lord, he has come. My lord, this is the.
And teacher people ratio was under clause
My lord,
D.
my lord, teacher people
Under
ratio.
clause D,
Yes, my lord.
which was said under that amendment not to apply in case of a medical transfer. Are you aware?
Lordship, in this matter, my lord.
I don't know if it's the same one or not.
Report to them.
এটা রিপোর্ট কি কোন রিপোর্টটা না রিপোর্টটা নেব
No, general test application.
It is the same rule. West Bengal School Service Commission General Transfer and Transfer on Special Ground Reallocation Rules.
Lordship.
2015.
Lordship.
Please come to an amendment of 8 September 2021.
ওটা আসেনি এখানে
Come to that.
কোথায় গেল দেখুন
একটা ক্লিক করে লাগাও বুঝলে এতে হ্যাঁ 15 days
অন্যদিকে ঘুরে গেল
এতে বলছি Rule 6 amend হয়েছে Rule 6 হচ্ছে তো you come to G C is come to C. Consider the number of the subject teacher and roll strength. If the resultant vacancy, consider the total application of more than 10%. It's on a ground of Rule 4A and 4A হচ্ছে medical well, it apply করবেন. We've seen that. How can a raw strength be taken into account? Have you seen? Have you got that?
My lord, at present, my lord, only I have my lord, the application form of the petitioner.
Sir, I'm telling you.
Lordship.
When in 2015 rule, there was a teacher people ratio
Lordship.
general transfer.
Lordship.
Then on September 8, 2021, there was an amendment brought.
Lordship. Sir.
By virtue of an amendment, Rule 4 was revamped.
My lord, amended.
Rule 4 says that an incumbent may apply online in a designated portal for transfer on following grounds.
Lordship.
A says any incumbent, his son, daughter, spouse suffering from a malignant disease, severe heart disease, renal failure, thalassemia, replacement of organ, serious gynecological disorder,
Lordship.
causing serious problem in attending the school.
Lordship.
Then physical disablement of 40% or more.
Lordship.
These are the
grounds for
Yes.
transfer.
Then Rule
Then he
6 is also amended.
Lordship.
Rule 6 talks about clause, sub-rule 2C, that upon submission of an application, the authority of the SMC shall consider the number of the subject teacher and roll strength.
Lordship.
If the resultant vacancy of the particular subject becomes 0 or not commensurate, the authority shall not forward the application. Then D says, consider the total application from the school is not more than 10%. But he says that the authority of the SMC shall dispense with the provision of clause C and D, which contains a Rolliston, for an application made on the grounds mentioned in 4A and 4D.
Lordship.
4A and 4D are medical grounds.
Now-
So Rolliston will not come. You have to. How can you?
My lord, here only ratio is being considered.
This is what the Rolliston you cannot ratio.
My lord, in page number 50, my lord, in the application.
What is the ground?
Ground,
for
bolo- ground.
Medical ground. I can. That is come within 4A. What is the where? What is the ground? Where is your application?
My lord, application is page number, my lord.
The application form is 26.
What is the disease? What is says?
No. No,
Gynecological disorder, my lord.
Gynecology.
Page 29. Page 29, paragraph 9. Gynecological first.
Right.
So it comes within 4A.
Yes, my lord.
There is a report of CMO is Kharagpur.
28. But
Page number 20.
ওটা করা যাবে, ওটা করা যাবে।
গাইনোকোলজি বলেছে কিন্তু কোনো গাইনোকোলজি সেখানে গিয়ে দেয়নি মাসকলটা এখানে আমি দেখেছি গাইনোকোলজি কোনো ইয়ে নেই
Sir,
কি করবেন
consider the application within
Lordship.
time.
follow that. I was in my lord. That rule, my lord, of primary, my lord. One rule is there in respect of this. Yes.
I read that rule 2015.
But only the
2015.
no.
2002 rules. You will say no. This rule does
My
not
lord,
apply.
that's. I shall come.
2002 rules apply.
Yes. No, calculate. Tomorrow.
Find out from the book 2002
Yes.
rules. Find out that it